Faculty of Law, University of Delhi, Delhi 110,007. July 2020. For private use only in the course of instruction E. Course name, Jurisprudence Act Legal Method. Course code, LB 101. Course objectives. To give an overview to the students about law and legal systems prevalent in the world and India in particular, so that they can understand the jurisprudence of all subjects taught to them over a span of 3 years. To learn the jurisprudential basis of various concepts which are continuously being dealt with in law in all manifestations. To sensitize the students to adopt a pragmatic approach in studying all the subjects in the 6 semesters by teaching them how to read cases and ways to club theory with practice. It is a subject which forms the foundation of the law degree. To make the students trace the evolution of law and legal systems in different countries. To familiarize the students with linkage of law with other social science such as psychology, history, sociology, economics, history, etc. To familiarize the students with the growth of legal profession in India and the laws governing the profession. Learning outcomes. Students will be acquainted with the basic ideas and fundamental principles of law in the given society. Knowledge of law and legal precepts will help the students to face exigencies of life boldly and courageously. Students will be inculcated with standards of ideal for human conduct in terms of law for the maintenance of public conscience. Students will be able to identify such pressing demand or problems which require solution within the parameters of the law, justice and other social norms. Course content. 1A. Major legal systems of the world. B. Indian legal system. I. N.R. Madhava Menon, A Legal System. O1. E. Rene David and J.E.C. Brierley, Major Legal Systems in the World Today 17 to 31, 484 to 515 3rd ed. 1985. 08. E. Joseph Manacher, Indian Legal System, Introduction VT 2nd ed. 2006 14. 2. Structure of Indian Legal System, Basic Principles of Law and Rule of Law. I. Hierarchy of Courts and Jurisdiction 19. E. Legal Services and Lok Adalat 22. E. Diocese Rule of Law 38. IV. Doctrine of Separation of Powers and its applicability in India 45. V. Method of Legal Study and Rules of Interpretation. Glanville Williams, Learning the Law, Chapter 7, The Interpretation of Statutes, pp. 97 to 108 11th ed. 12th Indian Reprint 2006 49. 3. A. Sources of Law. A. Custom. B. Legislation. C. Precedent. B. Legal Profession in India. I. M. P. Jan, Custom as a Source of Law in India, 3 Jaipur Law Journal 96 196356 E. Dias, Jurisprudence, Chapter 7, Justice in Deciding Disputes pp. 126 to 164 ed. 5. 2013 78 IV. E. Glanville Williams, Learning the Law, Chapter 6, Learning the Techniques pp. 67 to 79 11th ed. 12th Indian Reprint 2006 106 IV. Advocates Act, 1961 A. N. Veera Raghavan, Legal Profession and the Advocates Act, 1961, 14 Journal of the Indian Law Institute pp. 22826219721114. 4. Positive Analytical School of Thought. John Austin, Province of Jurisprudence determined 128 HLA Hart, Concept of Law. Law is the union of primary and secondary rules, and the foundation of a legal system. 155 and 168. 5. Hans Kelsen, Pure Theory of Law, 175. 6. Historical and Sociological School of Thought 208 Carl von Savigny Roscoe Pound 221. 7. Judicial Process Applying Theories of Law, Lon. L. Fuller, The Case of Spellinson Explore, 62 Harvard Law Review, 616 to 664, 1949. 227. 8. Rights and Duties. Dias, Jurisprudence, Concept of Rights and Duties, Jurisprudential Analysis. 247. Important note. 1. The topics, cases and suggested readings given above are not exhaustive. The committee of teachers teaching the course shall be at liberty to revise the topics, case suggested readings. 2. Students are required to study, refer to the legislations as amended from time to time, and consult the latest editions of books. Questions to ponder. Unit 1. 1. Discuss the major legal systems of the world and their impact on development of India's legal system. 2. What are the major components of Indian legal system? Unit 2. 1. Discuss the importance of legal aid and Lok Adalat as a means of providing easy access to justice. 2. To what extent Dicey, writing in Introduction to the Study of Law of the Constitution, 1885, has been influential in establishing the rule of law within the 19th century? Is application of rule of law a myth or reality in India? 3. Elaborate various rules of interpretation of the statutes. 4. How does the system of checks and balances reinforce the separation of powers? Discuss the application of theory of separation of powers in India. 5. Explain the hierarchy of court system in India and their jurisdiction. Unit 3. 1. Briefly discuss the objectives and the main features of the Advocates Act, 1961. Unit 4. 1. Critically examine Austin's view on sovereignty. How is a sovereign identified in the command theory of law? Also discuss the existence of a sovereign as a postulate in the current scenario in India. 2. Not all laws are expression of a wish by a sovereign, that some others behave in a certain way. In the light of the given statement, discuss Hart's concept of law. How does he define the two types of rules and what is the difference between the two rules? Unit 5. 1. What is role of sanctions in Kelson's legal order? Does it differ from Austin's idea of sanctions? 2. Can we locate a grand norm in the Indian legal system? 3. Are there any similarities and/or differences between H.L.A. Hart's rule of recognition and Kelson's grand norm? Unit 6. 1. Why did Savigny argue that legislation was subordinate to custom? Does Savigny's approach towards custom differ from the approach of positivists like Austin and Hart? 2. How far is the concept of Volksgeist relevant in contemporary legal discourse? 3. Does Pound's sociological jurisprudence challenge the idea of law propounded by the positivists? Unit 7. 1. The Spellinson Explorers case provides a window to look into the process of judicial decision making. Use any of the two given doctrines to show how the judges differed from each other in either reasoning or decision making while deciding the fate of the explorers. A doctrine of separation of powers and the morality of legalism. B. Varying rules of interpretation. C. Judges of the Supreme Court are to provide justice to the people and not merely provide judgment applying the law of the land in the given situation. Unit 8. 1. How does Hofeld's jural relations help in judicial reasoning and decision? 2. Is it possible to state legal problems with the help of Hofeld's 8 fundamental conceptions? Explain these conceptions with the aid of examples. Major legal systems in the world today. 1. A legal system. N.R. Madhava Menon. The legal system of a country is part of its social system and reflects the social, political, and cultural characteristics of that society. It is, therefore, difficult to understand the legal system outside the socio-cultural milieu in which it operates. It is true in the case of India also, even though the legal system we now have is largely the gift of the British rulers. There is a view that the system is still alien to the majority of Indians whose legal culture is more indigenous and whose contact with the formal legal system, the imported British model, is marginal if not altogether non-existent. The language, technicality and procedure of the inherited legal system are indeed factors which limit access to justice for the illiterate, impoverished masses of our country. Nevertheless, the rights and benefits conferred by the laws and the Constitution offer the opportunity for those very people to enjoy the fruits of a welfare democracy which the people of India have given unto themselves on the 26th of January 1950. It is in this context familiarity with law and its processes becomes essential to every Indian, rich or poor, man or woman, young or old. Components of a legal system. A legal system consists of certain basic principles and values largely outlined by the Constitution, a set of operational norms including rights and duties of citizens spelt out in laws, central, state and local, institutional structures for enforcement of the laws, and a cadre of legal personnel endowed with the responsibility of administering the system. The Constitution, the fundamental law of the land. The constitution of a country is variously described depending upon the nature of the policy and the aspirations of the people in a given society. It is generally a written document and assumes the character of a federal, several independent units joined together or unitary form of government. India is declared to be a socialist, secular, democratic republic. It is said to have a quasi-federal structure. The Constitution of India represents the collective will of 700 million Indians and, as such, the reservoir of enormous power. It describes the methods by which this power conferred on the state is to be exercised for the benefit of the people. In other words, it is a political document which distributes state power amongst different organs, central and state governments, legislative, executive and judicial wings of each government, and regulates its exercise in its incidence on the people. The form of government is democratic and republican, and the method is parliamentary through adult franchise. The goals are spelt out in preamble itself, which seeks to secure to all citizens justice, social, economic and political, liberty of thought, expression, faith and worship, equality of status and of opportunity, and to promote among them all major legal systems in the world today. 2. Fraternity, assuring dignity of the individual and the unity and integrity of nation. To achieve this goal of dignity of the individual with justice, liberty and equality, the Constitution guarantees certain fundamental rights and provides for its enforcement through the High Courts and the Supreme Court. These basic human rights include A. Equality before law. B. Equality of opportunity in matters of public employment. C. Prohibition of discrimination on grounds of religion, sex etc. D. Protection of life and personal liberty. A. Protection of right to freedom of speech, of assembly, of association, of movement and of profession or occupation. F. Prohibition of forced labor. G. Right to freedom of religion. H. Protection of interest of minorities. And I. Right to constitutional remedies for enforcement of the above rights. Further, towards achieving the goals set out in the preamble, the Constitution gives certain directives to state to follow in its policies and programs. Principles of state policy have been recognized to be as sacrosanct as fundamental rights. In other words, they together constitute a reference for state action in every sphere. The Constitution envisages a unique place for the judiciary. Apart from overseeing the exercise of state power by the executive and the legislatures of the state and the central governments, the Supreme Court and the High Courts are charged with the responsibility of effectively protecting citizens' rights through its writ jurisdiction. This offers a cheap and expeditious remedy to the citizen to enforce the guaranteed rights. The Supreme Court liberalized the rules so as to enable poor and illiterate citizens to have easy access to courts for enforcing their basic rights. The rule of law is supreme and the independence of judiciary is reality in our country. This forms the bulwark of democracy and compels everyone to abide the law in his own, be understood and subscribed to by every Indian if we are to succeed in our declared goals. Laws, civil and criminal. The laws of the country are too numerous, varied and complex. They are bound to be so because law is as large as life itself, which is increasingly becoming complex in every sphere. In a welfare state like ours, laws are at the most so because they are expected to regulate a variety of social and economic activities so as to subserve the common good. Inspired by the Constitution, Parliament, the state legislatures and local councils make and unmake the laws major legal systems in the world today. 3. Day in and day out as occasion demands. Courts interpret them in specific fact situations and, in the process, extend the scope and application of the laws. The common man may get lost in the maze of legislations coming from all sides and contribute to its complexity by creating his own laws through contracts and agreements with others he has to deal with. On the basis of the remedies sought and the procedure followed, all laws can be grouped into two categories, namely, civil laws and criminal laws. Broadly speaking, criminal law is concerned with wrongs against the community as a whole, while civil law is related to the rights, duties and obligations of individual members of the community between themselves. Civil law includes a number of aspects which may be grouped under 6 or 7 major headings such as family law, the law of property, the law of tort, the law of contract, the law relating to commerce and business, labor law, law of taxation etc. Family law, which in India has its source both on statute and religion, comprises of the laws governing marriage, divorce, maintenance, custody of children, adoption, inheritance and succession. Though the Constitution envisages a uniform civil code, each religious group at present follows largely its own norms in matrimonial and family relations. The law of property includes rights of ownership, transfer, mortgages, trusts, intestacy and similar matters. The law of contracts is concerned with the enforcement of obligations arising from agreements and promises. This includes transactions such as sale of goods, loans of money, partnerships, insurance, guarantees, negotiable instruments, agency and the like. The law of torts deals with propriety of actions and infraction of duties. Injuries to person or property caused by failure to take reasonable care and caution leads to actionable wrongs under tort, which usually compensates the victim of such injuries. Laws of commerce and business, which includes contract law, relate to economic operations of individuals, partnerships and companies and governmental regulation of them. Even law of taxation forms part of commercial laws. Labor law deals with the relationship between employer and employees in the production and distribution of wealth. Criminal law is concerned with public wrongs or wrongs against the order and well-being of the society in general. The persons guilty of such wrongs are prosecuted and punished by the state. These wrongs are specific and are defined in the penal code and a few other special and local laws. One important aspect in this regard is that criminal laws insist, apart from a few exceptional offenses, on a particular intent or state of mind as a necessary ingredient of a criminal offense. It also recognizes degrees of criminality and gradations of crime. Ignorance of law is never taken as an excuse. Certain situations where guilty intention could not have been entertained, such as infancy, insanity, mistake of fact, etc. They are recognized as defenses to criminal responsibility. Offenses are classified on the basis of the objective or otherwise. Thus, there are crimes against the human body, property, reputation of the individual, against the state or against public rights. Major legal systems in the world today. 4. On a procedural basis, they are classified as cognizable and non-cognizable. Cognizable are those in which the police can investigate or arrest persons without judicial warrant, bailable and non-bailable, compoundable or otherwise. Procedural laws, civil and criminal. Most proceedings in the Supreme Court and the High Courts are governed by rules of procedure made by the courts themselves under powers given by statute. The Civil and Criminal Procedure Codes and the Evidence Act do apply to judicial proceedings in these courts as well. The writ procedure under Articles 32 and 226 is unique to these courts and is intended for the quick enforcement of fundamental rights whenever they are threatened by the state or its agencies. In such situations, citizens can approach these courts even through a letter sent by post, as the Supreme Court has declared that procedure should not be allowed to come in the way of dispensation of justice. For the enforcement of civil rights and obligations, a suit before a civil court is usually instituted. The procedures for trial and appeals, including execution of decrees and orders, are laid down in the Code of Civil Procedure. Variationism for purposes of jurisdiction is made according to the Suits Valuation Act. The amount of court fees to be paid on plaints and appeals is determined by the Court Fees Act. The Limitation Act prescribes the periods of limitation within which suits can be filed. The Evidence Act regulates the relevancy, admissibility and probative value of evidence led in courts, civil and criminal. The trial is in the nature of adversary proceedings where two parties oppose each other in a suit or action between parties. The procedure commences with pleadings, which set out the precise question in dispute or the cause of action. The opposite party, the defendant, may file a written statement to admit or deny the allegations in the plaint. The pleadings may be supplemented by the parties by making admissions of fact, answers and interrogatories, oral statements before the court, and by admissions and denials of documents filed by them. The hearing of a suit commences with the serving of a copy of the plaint to the defendant. A party can appear himself in court for the hearing or make appearance through an agent or a pleader. According to the Advocates Act, right to practice law before courts is given to advocates only. In the proceedings, parties have to summon their witnesses for deposing in court. The trial involves recording of evidence of witnesses on a day-to-day basis, at the conclusion of which judgment is to be pronounced in open court. Because civil proceedings are private matters, they can at any time be abandoned or compromised, and, in fact, in a number of cases they are settled before trial. Major legal systems in the world today. 5. Judgments are enforceable through the authority of the court. Refusal to obey a judgment may lead to penal consequences. Many decrees are open to appeal in higher courts within the specified period. Criminal proceedings are governed by the provisions of the Code of Criminal Procedure, the purpose of which is to determine whether the accused is guilty of the offense charged and, if so, to decide the punishment to be awarded therefor. It is designed to give every accused a fair trial, consistent with the constitutional commitment to individual liberty and freedom. A criminal proceeding involves 4 major stages, namely, investigation, prosecution, trial and disposition. Crimes being wrongs against society, the state undertakes the prosecution on behalf of the victim. The police, on receiving information of the commission of an offense, proceeds with the investigation. They are authorized to interrogate people, arrest the suspects with warrant from the magistrate in non-cognizable cases, search places for recovery of relevant materials, seize property connected with the crime, and prepare a report on their findings for necessary action by the prosecuting authorities. Whenever arrests are made, they are obliged to produce the arrested person before the nearest magistrate within 24 hours. They are not to use third-degree methods in interrogation, and confession given to police is not admissible as evidence in court. In all bailable cases, they are bound to release the person on bail. The arrested person has right to seek the aid of a lawyer of his choice, and he cannot be compelled to give evidence against himself. Under our law, every accused is presumed innocent, and the prosecution, the state, has to prove the guilt beyond a reasonable doubt. If there is any doubt in the evidence or the prosecution, the benefit of doubt is given to the accused and he is acquitted. The defendant has the right to cross-examine every prosecution witness, while he cannot himself be questioned unless he consents to be sworn as a witness in his own defense. In the case of indigent persons, there is provision for legal aid at the state expense. If at the end of trial, the judge finds him guilty, he has a right to be heard on the determination of sentence. The emphasis in modern criminal justice being reformation and rehabilitation, there is enough scope for a deserving convict to get correctional treatment as part of sentence. Apart from the civil and criminal proceedings prescribed in the respective codes, there are a variety of adjudicative procedures followed in tribunals, quasi-judicial administrative agencies, arbitration councils, Nyay Panchayats etc., where private disputes are processed and settled through informal procedures. They are found to be cheap, expeditious, and less cumbersome in terms of adjudication. Major legal systems in the world today. 6. Legal aid has now assumed an important place in judicial procedure in country. Right to counsel by a lawyer of one's choice is a constitutional right every citizen possesses. In the case of poor person, the Criminal Procedure Code provides for the appointment of counsel at state expense to defend the indigent accused in all major criminal cases. In civil proceedings, a poor person can declare himself to be a pauper, in which case he is exempted from company fees and a variety of related court expenses. Legal aid schemes set up in state also provide such persons with the services of lawyers to conduct litigation on their behalf. Courts of law. Courts are institutions wherein disputes are adjudicated and justice administered. They are created by statutes and enjoy such powers and jurisdiction, which the statutes confer. The Constitution itself provides for the Supreme Court and the High Court in each state at the apex of the judicial system, and confers original and appellate jurisdiction on them primarily to resolve disputes between Union and the state, state and state, state and the citizen, and in limited cases appeals arising out of private disputes involving substantial questions of law. This higher judiciary is named as the Union Judiciary, and appointments to it are made by the President of the Union on the advice of the Chief Justice. Citizens can directly approach the High Courts or the Supreme Court to seek redress for the violation of fundamental rights. These courts have a supervisory function over the subordinate courts, state judiciary, which are set up by each state according to its requirements under the Civil Procedure Code, Criminal Procedure Code, or other state laws. The High Courts and Supreme Court enjoy civil and criminal jurisdiction apart from the writ jurisdiction. The state judiciary under the High Court is organized in a hierarchy on the civil and criminal sides based on their jurisdiction, territorial or monetary. On the criminal side, the Criminal Procedure Code provides for the magistrates' court first or second class depending on the extent of powers for punishment, and above them the sessions courts, usually one in each district. On the civil side, the Civil Procedure Code provides for the Municip's Court with limited pecuniary jurisdiction, the Subdivisional Court, and the District Court, each with varying pecuniary and territorial jurisdiction. There can be special courts set up for specific purposes, and also administrative and revenue tribunals to adjudicate upon specific categories of disputes. Thus, there are motor vehicles compensation tribunals, sales tax tribunals etc., all of which are judicial bodies adjudicating disputes in the areas assigned to them. Appeals from these courts and tribunals usually lie to the High Courts and, in exceptional cases, a second appeal to the Supreme Court. The personnel of the law. Administration of justice requires the cooperation not only of the parties and the judges but also of officers of court, who include the advocates, the court staff, and the para-legal personnel who assist the lawyers and judges. Major legal systems in the world today. 7. Judges. All judicial officers from the Supreme Court judge to the Municip in a small taluka are independent of both the legislature and the executive. They are free to administer law without fear or favor, and they cannot be interfered with by anyone, including the top functionary of the government. They have the power to punish those who commit contempt of court or disobey their legitimate orders. The President, acting on the advice of the Cabinet and the Chief Justice of India, appoints the judges of the Supreme Court and the High Court. The Governor of the state appoints the judicial officers of the state, similarly on the advice of the state High Court government. Their salaries and service conditions are determined by law and cannot be changed to their disadvantage. Their removal from service requires a special procedure and the control of their judicial functions vests on the higher judiciary. Lawyers in the bar. Lawyers are the key functionaries assisting the judges in the administration of justice. They are officers of court and are constituted into an independent profession under an Act of Parliament. The Advocates Act, 1961. No others may practice before the courts. Without the expert assistance of lawyers on either side of a dispute, judges will find it difficult to find the truth on disputed facts in issue and interpret the law applicable to varied situations. That is why the legal profession is often referred to as a noble and a learned profession. There are at present approximately 230,000 advocates practicing in the various courts in the country. For organizational purposes, they have formed themselves into bar associations. They are enrolled into the profession by the Bar Council created by Parliament under the Advocates Act. The bar councils at the state level and the central level consist of elected members of the profession who undertake the responsibility of not only admitting new entrants, but also improving the quality of legal services, particularly through the exercise of disciplinary powers over erring members of the profession. Legal services to the poor is one of the social obligation of every lawyer required under the Bar Council rules of professional conduct. Major legal systems in the world today. 8. Major legal systems in the world today. René David and John E. C. Brierly. There would appear to be three at least which occupy uncontested place of prominence: the Romano-Germanic family, the common law family and the family of socialist law. These three groups, whatever their value and extension throughout the world, do not however take into account all contemporary legal phenomena. There are other systems, situated outside these three traditions or sharing only part of their conception of things, which prevail in a large number of contemporary societies, and in their regard to, a number of observations will be furnished. Romano-Germanic family or first family may be called the Romano-Germanic family. This group includes those countries in which legal science has developed on the basis of Roman jus civile. Here the rules of law are conceived as rules of conduct intimately linked to ideas of justice and morality. To ascertain and formulate these rules falls principally to legal scholars who, absorbed by this task of enunciating the doctrine on an aspect of the law, are somewhat less interested in its actual administration and practical application. These matters are the responsibility of the administration and legal practitioners. Another feature of this family is that the law has evolved, primarily for historical reasons, as an essentially private law, as a means of regulating the private relationships between individual citizens. Other branches of law were developed later, but less perfectly, according to the principles of the civil law, which today still remains the main branch of legal science. Since the 19th century, a distinctive feature of the family has been the fact that its various member countries have attached special importance to enacted legislation in the form of codes. The Romano-Germanic family of laws originated in Europe. It was found by the scholarly efforts of the European universities which, from the 12th century and on the basis of the compilations of the Emperor Justinian AD 483 to 565, evolved and developed a juridical science common to all and adapted to the conditions of the modern world. The term Romano-Germanic is selected to acknowledge the joint effort of the universities of both Latin and Germanic countries. Through colonization by European nations, the Romano-Germanic family has conquered vast territories where the legal systems either belong or are related to this family. The phenomenon of voluntary reception has produced the same result in other countries which were not colonized, but where the need for modernization, or the desire to westernize, has led to the penetration of European ideas. Outside Europe, its place of origin, these laws, although retaining membership in the Romano-Germanic family, nonetheless have their own characteristics which, from a sociological point of view, make it necessary to place them in distinct groups. In many of these countries it has been possible to receive European laws, even though they possessed their own civilization, had their own ways of thinking and acting and their own indigenous institutions, all of which antedate such reception. Sometimes reception has left some of these major legal systems in the world today. 9. Original institutions in place. This is particularly clear in the case of Muslim countries where the reception of European law and the adhesion to the Romano-Germanic family have been only partial, leaving some legal relations subject to the principles of the traditional, local law. The old ways of thinking and acting peculiar to these countries may also mean that the application of the new has been quite different from what it is in Europe. This question is particularly important in the case of the countries of the Far East, where an ancient and rich civilization existed long before the reception of Western law. Finally, with respect to the countries of Africa and America, it will also be necessary to ask whether their geographical conditions and populations distribution, creating conditions entirely different from those in Europe, have not led to the development of laws substantially different from their European models. Common law family. A second family is that of the common law, including the law of England and those laws modeled on English law. The common law, altogether different in its characteristics from the Romano-Germanic family, was formed primarily by judges who had to resolve specific disputes. Today it still bears striking traces of its origins. The common law legal rule is one which seeks to provide the solution to a trial rather than to formulate a general rule of conduct for the future. It is then much less abstract than the characteristic legal rule of the Romano-Germanic family. Matters relating to the administration of justice, procedure, evidence and execution of judgments have, for common law lawyers, an importance equal, or even superior, to substantive legal rules because, historically, their immediate preoccupation has been to re-establish peace rather than articulate a moral basis for the social order. Finally, the origins of the common law are linked to royal power. It was developed as a system in those cases where the peace of the English kingdom was threatened, or when some other important consideration required, or justified, the intervention of royal power. It seems, essentially, to be a public law, for contestations between private individuals did not fall within the purview of the common law courts save to the extent that they involved the interest of the crown or kingdom. In the formation and development of the common law or public law issuing from procedure, the learning of the Romanists founded on the jus civile played only a very minor role. The divisions of the common law, its concepts and vocabulary, and the methods of the common law lawyer, are entirely different from those of the Romano-Germanic family. And as with the Romano-Germanic family, so too the common law has experienced a considerable expansion throughout the world and for the same reasons, colonization or reception. The observations made with respect to the Romano-Germanic family apply with equal value. But here again a distinction between the common law in Europe, England and Ireland and that outside Europe must be made. In certain extra-European countries, the common law may have been only partially received as in the case, for example, of certain of Muslim countries or India, and where it was received, attention must be given to its transformation or adoption by reason of its coexistence with the tradition of previous civilizations. A different environment has, in any event, created difference between the common law of the countries where it originated and that of those into which it was imported. This observation is particularly true with respect of the common law family because it groups some countries such as the United States and Canada where a civilization major legal systems in the world today. 10. Different in many respects from that of England has developed. The laws of these countries enjoy a largely autonomous place within the family. Relations between these two families over the centuries. There have been numerous contacts between countries of the Romano-Germanic family and those of the common law, and the two families have tended, particularly in recent years, to draw closer together. In both, the law has undergone the influence of Christian morality and, since the Renaissance, philosophical teachings have given prominence to individualism, liberalism and personal rights. Henceforth, at least for certain purposes, this reconciliation enables us to speak of one great family of Western law. The common law retains, to be sure, its own particular structure, very different from that of the Romano-Germanic system, but the methods employed in each are not wholly dissimilar. Above all, the formulation of the legal rule tends more and more to be conceived in common law countries as it is in the countries of the Romano-Germanic family. As to the substance of the law, a shared vision of justice has often produced very similar answers to common problems in both sets of countries. The inclination to speak of a family of Western law is all the stronger when one considers that the laws of some states cannot be annexed to either family, because they embody both Romano-Germanic and common law elements. The laws of Scotland, Israel, the Union of South Africa, the province of Quebec and the Sophies in which the place and function of law are very different from what they are in the West. A true picture of law in contemporary world society would be incomplete without taking these considerations into account. In non-Western societies, the governing social principles to which reference is made are of two types. On the one hand, law is fully recognized as being of great value, but the law itself is framed in a different concept than it is in the West. On the other, the very notion of law is rejected, and social relations are governed by other extra-legal means. The first view is that of Muslim and Hindu societies, while the latter is that adopted in countries of the Far East and large parts of Africa and Malagasy. Family of socialist laws. The socialist legal system makes up a third family, distinct from the first two. To date, the members of the socialist camp are those countries which formerly belonged to the Romano-Germanic family, and they have preserved some of the characteristics of Romano-Germanic law. Thus, the legal rule is still conceived in the form of a general rule of conduct. And the divisions of law and legal terminology have also remained, to a very large extent, the product of the legal science constructed on the basis of the Roman law by European universities. But apart from points of similarity, there do exist such differences that it seems proper to consider the socialist laws as detached from the Romano-Germanic family. The socialist jurists most decidedly do, and as constituting a distinct legal family, at least at the present time. The originality of socialist law is particularly evident because of its revolutionary nature. In opposition to the somewhat static character of Romano-Germanic laws, the proclaimed ambition of socialist jurists is to overturn society and create the conditions of a new social major legal systems in the world today. 11. Order in which the very concepts of state and law will disappear. The sole source of socialist rules of law resides therefore within the revolutionary work of the legislature, which expresses popular will, narrowly guided by the Communist Party. However, legal science as such is not principally counted upon to create the new order. Law, according to Marxism-Leninism, a scientific truth, is strictly subordinate to the task of creating a new economic structure. In execution of this teaching, all means of production have been collectivized. As a result, the field of possible private law relationships between citizens is extraordinarily limited compared to the pre-Marxist period. Private law has lost its preeminence. All law has now become public law. This new concept removes from the very realm of law a whole series of rules which jurists of bourgeois countries would consider legal rules. The family of socialist laws originated in the Union of Soviet Socialist Republics, where these ideas prevailed, and a new law has developed since the 1917 revolution. However, the laws of the socialist or people's republics of Europe and Asia must be classed as groups distinct from Soviet law. These laws belong to the socialist family. But in those of the first group, a greater persistence of characteristics properly Romano-Germanic is detected, while in those of the second it is useful to inquire how these new concepts are reconciled in practice with the principles of Far Eastern civilization which governed such societies before the socialist era. Other systems, the three families just described, each of which is numerous variants, are undoubtedly the three principal families of law existing in the contemporary world. Strictly speaking, there is no law in the world today which has not drawn certain of its elements from one or other of these families. Some even hold the view that all other systems, no more than survivors from the past, will ultimately disappear with the passing of time and the progress of civilization. This attitude, however, proceeds from a rather native sense of superiority and is really no more than an hypothesis. It does not acknowledge an observable reality in the modern world. All contemporary states have, it is true, taken over a number of Western ideas either because it was necessary to preserve their independence or because it was useful in their internal development. It does not follow that the older ways of thinking which, not so very long ago, were widely accepted in these different societies have been totally abandoned. Everyone will recognize the superiority of Western technology. Opinions differ, however, on the superiority of Western civilization taken as a whole. The Muslim world, India, the Far East and Africa are far from having adhered to it without reservation. These countries remain very largely faithful to philo society, must act legally, courts must ensure that law is respected. Law, a mirror of justice, is in this conception superior even to equity itself. Outside the law, there can only be anarchy, or arbitrariness, chaos, or the rule of force. Law is therefore venerated, the courts are temples of justice, the judges its oracles. Far Eastern countries reject this view. For the Chinese, law is an instrument of arbitrary action rather than the symbol of justice. It is a factor contributing to social disorder rather than to social order. The good citizen must not concern himself with law. He should live in a way which excludes any revindication of his rights or any recourse to the justice of courts. The conduct of individuals must, unfailingly, be animated by the search for harmony and peace through methods other than the law. Man's first concern should not be to respect the major legal systems in the world today. 12. Law. Reconciliation is greater value than justice. Mediation must be used to remove conflicts rather than invoking law to resolve them. Laws may exist to serve as a method of intimidation or as a model. But law is not made with a view to being really applied, as in the West, scorn is reserved for those who aspire to regulate matters according to law or whose preoccupation is its study or application, and who thereby defy convention and accepted proprieties. Countries of the Far East have, traditionally, held the view that law is only for barbarians. The Chinese communist regime and the westernization of Japan have not fundamentally changed this conception rooted as it in their ancient civilizations. In China, the communist regime rejected the legal codes drawn up after the fall of imperial rule along Western lines and, after some brief hesitation, then repudiated the Soviet method of building communism. The techniques finally adopted for doing so have given up to the present time a very narrow place to law. Codes on the European model have been instituted in Japan, but, generally speaking, the populations makes little use of them. People abstain from using the courts and the courts themselves encourage litigants to resort to reconciliation. And new techniques have been developed for applying or removing the need of applying the law. Muslim, Hindu, and Jewish laws. The attitude of the Muslim, Hindu and Jewish communities about the law is easily understood by a Western jurist, even though the definition of law itself in Western jurisprudence has always given rise to difficulties and no single definition has so far elicited any general acceptance. One of the fundamental reasons for this lack of agreement is the debate between the proponents and adversaries of the notion of natural law. But it is because the idea of natural law exists that we are able to understand the starting premise of these other systems. In this debate, law is held by some to be no more than the body of rules that are really observed, the application of which is entrusted to the courts. This is the view today to our Western universities in which our national laws are taught. But law may also be seen as a model of ideal behavior, one not to be confused with the actual rules by which individuals act which courts apply. European universities, in their pre-19th century tradition, paid very little attention to national or customary laws of the time and taught, almost exclusively, an ideal law constructed on the basis of Roman law. In Muslim countries, in the same way, more attention is given to the model law linked to the Islamic religion than to local custom treated as a phenomenon of fact, or the laws and decrees of the sovereign treated as merely administrative measures, and neither of these is thought to possess the full dignity of law. The same can be said of Jewish law and, in a very different context, Hindu law. Law, then, whether linked to a religion or corresponding to a particularly way of thinking about the social order, is not in either case always necessarily observed by private persons or applied by courts. It may nonetheless exert considerable influence on both. Righteous men may endeavor to rule their own lives according to what they consider to be truly the law. A student of Western societies may well in a positivist perspective concentrate attention upon the rules enacted by legislatures and applied by court or, alternatively, in a sociological perspective, classify as law only those rules which are really observed as a matter of practice. This difference in approach is not a source of any real inconvenience because in Western major legal systems in the world today, 13 societies there is a large degree of equivalence between justice, positive law and social manners. The same cannot, however, be said of non-Western societies where rules of law, in the Western sense, remain unorganized, fragmentary and unstable, and where there is generally feeling that true law is to be found elsewhere than in legislation, custom or judicial decisions. Without taking sides in the debate between positivists and advocates of natural law, Muslim and Hindu law, therefore, must be included within the major contemporary legal systems. Jewish law, despite its historical and philosophical interest, must be omitted because its sphere of influence is incomparably less than that the other two. Far East. The situation in the Far East, especially China, is completely different. Here there is no question of studying an ideal law distant from rules laid down by legislators or simply followed in practice. Here the very value of law itself has traditionally been put into question. In the West, and in Islamic and Hindu communities, law is held to be a necessary part of, indeed a basis for, society. Good social order implies the primacy of law. Men must live according to law and, where necessary, be prepared to fight for the supremacy of law. Administrative authorities, no less than any other part of Philippines, would fall into this group. And lastly, but from another point of view, the Romano-Germanic and common law families are included in the same deliberately ignominious term of capitalist or bourgeois laws by jurists of the socialist camp, made up of the Soviet Union and those countries that have used its law as a model or which, like the USSR, profess an adherence to Marxist-Leninist teachings. Black Africa and Malagasy Republic. The preceding observations regarding the Far East apply as well to the Black African countries and the Malagasy Republic, Madagascar. There too, in milieu in which the community cohesion prevails over any developed sense of individualism. The principal objective is the maintenance or restoration of harmony rather than respect for law. The Western laws adopted in Africa are often hardly more than a veneer. The vast majority of the population still lives according to traditional ways which do not comprise what we in the West call law and without heed to what is very often nothing more than an artificially implanted body of rules. The Indian legal system. 14. The Indian legal system. Joseph Minettur. Introduction. To delve among the laws of India is like bathing in the holy waters of Triveni. It leaves one refreshed and delighted. Refreshed from the pleasant contact with almost all the legal systems of the contemporary world, and delighted at the hopeful realization that here in the Indian legal system lie the seeds of a unified, eclectic legal order which may soon grow into maturity and spread its branches, like a banyan tree, all over South and Southeast Asia. Three main streams join together to form the Indian legal system. That of the common law is perhaps the most dominant among them. Then there is the stream of laws springing from religion. The third is that of the civil Romanist law, which energizes the system with unruffled ethical verve and accords comeliness to its contours. Trickles of customary laws cherished by tribal societies and other ethnic communities also flow into the mainstream. Like the Saraswati near Prayag, the element of the civil law is not easily perceptible, though it permeates the entire structure. So a word of explanation is perhaps warranted. The very idea to a code appears to have been derived from the codes of continental Europe. When in 1788 a codification of Hindu law on contracts and succession was proposed by Sir William Jones to Lord Cornwallis, it was conceived to be on the model of the unestimable Pandects of Justinian. On the 18th of May 1783, a regulation for forming into a regular code, or regulations that may be enacted for the internal government of the British territories in Bengal, was passed by the Governor-General and Council. Some 8 years earlier, in 1775, Warren Hastings had a code of Gentoo laws or ordinations of the Pandits prepared and translated by Halt, a judge of the Supreme Court at Calcutta. The same year Bentham offered to act as a sort of Indian Solon, and thought of constructing an Indian constitutional code. James Mill, one of his disciples at India House, thought that his draft of a new plan for the France was applicable to India. Speaking on the Charter Bill of 1833, Macaulay said, "I believe that no country ever stood so much in need of a code of laws as India, and I believe also that never was a country in which the want might so easily be supplied." Section 53 of the Charter Act, 1853 declared that it was expedient that such laws as may be applicable in common to all classes of the inhabitants. Due regard being had to the rights, feelings and peculiar usages of the people, should be enacted, and that all laws and customs having the force of law should be ascertained and consolidated and, as occasion may require, amended. The first Law Commission immediately after its appointment in 1833 with Macaulay as its president took up the task of codification. Under Macaulay's personal direction it prepared its first draft of the Indian Penal Code and submitted it to the Governor-General in Council on the 14th of October 1837. When there were complaints that the progress of the Commission's work was unsatisfactory, Macaulay compared its progress with that of the authors of the French codes. He pointed out that though the French Criminal Code was begun in March 1801, the Indian legal system 15. Code of Criminal Procedure was not completed till 1810. It is also interesting to find half of the last century were on the same branches of law as with the French codes enacted earlier. Neither in India nor in France was enacted a code on the law of civil wrongs. It is true that there was no comprehensive enactment on torts in England, but then there were no comprehensive enactments in England on any of the subjects covered by the Indian codes. It is not only in cherishing the idea of codification that the British Indian authorities, executive as well as legislative bodies, appear to have been indebted to continental codes. As early as 1686, in a letter sent to Bombay, the directors of the East India Company had expressed the view that, "You were to govern our people there, being subject to us under His Majesty by the law martial and the civil law, which is only proper to India." The first Law Commission which drafted the Indian Penal Code acknowledged its indebtedness to the French Penal Code. In a letter of the 2nd of May 1837 addressed to the Governor-General, the Commission stated that it derived much valuable assistance from the French Code and from the decisions of the French courts of justice on questions touching the construction of that code. It derived assistance still more valuable from the Code of Louisiana prepared by the late Mr. Livingston. The Second Law Commission, which sat in London from 1853 to 1856, expressed its view that, what India wants is a body of substantive civil law, in preparing which the law of England should be used as a basis. It, however, emphasized that such a body of law ought to be prepared with a constant regard to the conditions and institutions of India, and the character, religious and usages of the population. It also stated that in the social condition existing in India, it was necessary to allow certain general classes of persons to have special laws, recognized and enforced by our courts of justice, with respect to certain kinds of transaction among themselves. The Commission gave final shape to Macaulay's Penal Code. It also prepared drafts of the Code of Civil Procedure and the Code of Criminal Procedure, incorporating into them materials left by the First Law Commission. The Legislative Council adopted the Code of Civil Procedure in 1859, the Penal Code in 1860 and the Code of Criminal Procedure in 1861. The Third Law Commission, appointed in 1861, was enjoined to prepare for India a body of substantive law, in preparing which the law of England should be used as a basis. The Fourth Law Commission expressed a similar view when it recommended in 1879 that English law should be made the basis in a great measure of our future codes, but its materials should be recast rather than adopted without modification. It, however, added that in recasting those materials due regard should be had to native habits and modes of thought. The influence of Scots and their law on the framing and adoption of the early British India codes and other enactments deserves to be mentioned. For a number of Scots in the 19th century, their prospects were not only along the highway to London, but from there across the Indian legal system. 16. High seas to Indian ports. Macaulay himself was of Scottish descent. Even when Scots were members of the English bar, they were imbued with concepts derived from the civil law system. In the same way they would prefer to preserve Scots law unsullied by English notions of legal rule, they were inclined to keep Indian law unsullied by intrusions and erosions to English rules of law intended to give due regard to native habits and modes of thought. We shall refer to few instances where the influence of the civil law is clearly discernible. Section 11 of the Indian Evidence Act adopted in 1872 could not have been enacted in a fit of absent-mindedness. The section which lays down guidelines to determine relevance in the admissibility of evidence is a clear, and presumably a deliberate, departure from the English rule and brings the Indian law in this respect very relevant and fair. Another provision which is of interest in this regard is Section 165 of the Act. Commenting on it, Stephen has said, Section 165 is intended to arm the judge with the most extensive power possible for the purpose of getting at the truth. The effect of this section is that in order to get to the bottom of the matter before it, the court will be able to look at and inquire into every fact whatever. The Indian judge appears to be invested with ample powers under the Act to get at the truth and form his own conviction at time. It is not unfamiliar learning that the framers of the Indian Contract Act adopted several provisions of the draft New York Civil Code. The Contract Act, which does not purport to be a complete code, only defines and amends certain parts of the law of contract, so that a rule of the Hindu law of contract like damduput is not abrogated. The rule stipulates that interest exceeding the amount of principal cannot be recovered at any time. It is still in force in some parts of India. The reason for not interfering with a rule like this must have been the sense of fairness cherished by the framers of the Act, though no such rule existed in English law. In the law of contract, consideration plays a significant role in India as in England. But the words of Section 25 of the Indian Contract Act, which accords validity to a registered agreement, even though without consideration, appear to reflect the concept of cause in French law. In this brief introduction, it is not intended to indicate all departures from English law in the Indian statutes. It may, however, be emphasized that when such departures were made, the legislators were generally induced to do so on consideration of what they thought suited Indian conditions or on considerations of equity. It is generally assumed that India is a common law country. This assumption may have been justified to a certain extent if applied to British India. It is true that many of the concepts and most of the judicial techniques are of common law origin. But there is more than a sprinkling of other concepts and techniques, which cannot be. It is true that many of the concepts and most of the judicial techniques are of common law origin. But there is more than a sprinkling of other concepts and techniques, which cannot be overlooked. Overlooked. Indian codes or But there is more than a. It is true that many of the concepts and most of the judicial techniques are of common law origin. But there is more than a sprinkling of other concepts and techniques, which cannot be overlooked. Indian codes or judicial procedure owe a great deal to procedure in England. But with the introduction of Nyay Panchayats, village tribunals which are indigenous in origin, the English procedure has been virtually replaced at the grassroots level. The functioning of Nyay Panchayats may not be as widespread as is desired. The fact, however, remains that at present there is a less formal the Indian legal system. 17. Procedure than the one followed until recent years. There is also general dissatisfaction, if not hostility, to the complex, protracted procedure derived from the common law system. With the reign of dharma, which may be equated with equity while it comprises the concept of law unopposed to justice, there was no need in India to think of a separate branch of law known as equity detached from common law. We have already adverted to certain departures from English law even when rules of English law were believed to have been codified for the benefit of the Indian people. Neither the expression, justice and right, in the Charter of 1726 nor the phrase, equity and good conscience, or justice, equity and good conscience, in several regulations and acts could have meant principles of English law. The Judicial Committee of the Privy Council was careful in its use of words when it pointed out that equity and good conscience had been generally interpreted to mean rules of English law if found applicable to Indian society and circumstances. It has been observed that from 1880 or thereabout to the present day, the formula has meant consultation of various systems of law according to the context. At present, the Supreme Court of India is inclined to think that the phrase has given a connotation consonant with Indian conditions. In the early 1960s, a number of territories where the civil law prevailed became parts of the Indian Union. In the Union Territory of Goa, Daman and Diu, Portuguese civil law was in force. Even after the extension of several Indian enactments to the territory, it is generally the provisions of the Portuguese Civil Code which apply to the people of this territory in matters of personal law. In the former French settlements of Pondicherry, Karaikal, Mahe and Yanam, which, when ceded, were formed into the Union Territory now known as Pondicherry, there are Indian citizens who are governed in matters of personal law by the provisions of the French Civil Code as they existed at the time of the cession. There are also other renouncants who are French citizens living in Pondicherry to whom provisions of the French Civil Code relative to personal law will apply with all subsequent amendments. In these circumstances, the element of the civil law in the fabric of Indian law cannot be brushed aside as negligible. And this element affects domestic relations which are a negligible part of a citizen's life. The customary laws of various tribal communities and other ethnic groups also form part of the law administered in India. To cite one instance, matrimony among the Mappila Muslims of Kerala, though not favored by the tenets of Islam, is permitted to play a decisive role in the rules of succession applicable to them. In the light of the presence and prevalence of French and Portuguese laws, customary law of various ethnic groups and laws based on religion of the several communities, the introduction of indigenous judicial procedures in village tribunals and several other factors, one cannot possibly close one's eyes and regard the Indian legal system as belonging to the common law family. It would be more justified to regard it as a mixed system. If Indonesian law with its admixture of customary laws based on religion could be regarded as a mixed system, there is no reason why Indian law should not be so regarded. Though the provisions of the French and the Portuguese civil codes relative to domestic relations are in operation in certain regions only, laws grounded in religion or custom are followed all over the country. The mosaic of Indian law may have a large number of common law pieces, but marble the Indian legal system. 18. Quarried from France and Portugal, gold leaves brought from Arabia and clusters of precious stones gleaned from Indian fields do deserve to be discarded. When India adopts a civil code, under the directive in the constitution it is likely to be eclectic in character. It may have in it a harmonious admixture of various laws based on religion and customary laws, as well as provisions derived from Western codes and the English common law. Owing to its eclectic character and especially because it would attempt to harmonize provisions of personal laws derived from religion prevalent in the region, the civil code may be found worthy of emulation in South and Southeast Asia. It may thus pave the way for unification of laws, though perhaps limited geographically in extent. If in ancient days, Indian culture was permitted, without any hitch or demur, to permeate social and political institutions and life in general in this region, there is no reason why Indian legal culture cannot play a similar role in the near future as well. The Indian Prime Minister recently expressed his hope that during the next 9 years, India would achieve significant progress in every field and would provide guidance and inspiration to other countries. He also stressed that India's influence had been increasing in Southeast Asia and West Asia. Even when one is not sure whether the mention of 9 years has any special significance, one can hopefully assume that if an Indian civil code is adopted soon, it may tend to guide and inspire legislators in the neighboring states. What the Napoleonic Code has done for continental Europe, the Americas, and parts of Asia and Africa, a well-framed Indian civil code may easily do for South and Southeast Asia. The Indian legal system. 19. Hierarchy of courts. 20. 21-22. Legal and Lok Adalat. R. Swaroop. Need for introduction of an adequate and comprehensive legal aid service program had been felt for many years, and it was increasingly being realized that there could not be any real equality in criminal cases unless the accused got a fair trial of defending himself against the charges laid and unless he had competent professional assistance. In Hassanara Khatun v. State of Bihar A 1979 SC 1369, 1375, the Supreme Court observed that it was not possible to reach the benefits of the legal process to the poor, to protect them against injustice and to secure to them their constitutional and statutory rights unless there was a nationwide legal service program to provide free legal services to them. Impressing upon the Government of India as also the state governments, the urgent necessity of introducing a dynamic and comprehensive legal service program with a view to reaching justice to the common man, the Supreme Court in Hassanara Khatun case observed, today, unfortunately, in our country the poor are priced out of the judicial system with the result that they are losing faith in the capacity of our legal system to bring about changes in their life conditions and to deliver justice to them. The poor in their contact with the legal system have always been on the wrong side of the line. They have always come across law for the poor, rather than law of the poor. The law is regarded by them as something mysterious and forbidding, always taking something away from them and not as a positive and constructive social device for changing the social economic order and improving their life conditions by conferring rights and benefits on them. The result is that the legal system has lost its credibility for the weaker sections of the community. It is, therefore, necessary that we should inject equal justice into legality, and that can be done only by dynamic and activism scheme of legal services. We would strongly recommend to the Government of India and the state governments that it is high time that a comprehensive legal service program is introduced in the country. That is not only a mandate of equal justice implicit in Article 14 and right to life and liberty conferred by Article 21, but also the compulsion of the constitutional directive embodied in Article 39A. The state cannot, therefore, avoid its constitutional obligation to provide free legal aid to the accused by pleading financial or administrative inability. The state is under a constitutional mandate of equal justice implicit in Article 14 and right to life and liberty conferred by Article 21, but also the compulsion of the constitutional directive embodied in Article 39A, to ensure fair trial, and whatever is necessary for this purpose has to be done by the state. It is also the constitutional obligation of the court, as the guardian of the fundamental rights of the people, as a sentinel on the qui-vive, to enforce the fundamental right of the accused to fair trial and his right to free legal aid, to secure assistance of a counsel, where he cannot afford to engage one, on account of indigence or poverty. There are several reasons why the right to legal aid to avail legal services in a country like India, which is under developing, democratic republic, wherein the welfare state, 23. doctrine has been adopted, assumes wider significance. There are several reasons, aspects and facets prevalent in this country, which would prompt to have a very effective, useful and efficient infrastructure for providing free and competent legal aid in a country like India, where less than 33% of the people know how to write and read sufficiently and usefully. Majority of the people are poor or indigent, and most of them live below the poverty line, even though poverty line is drawn liberally, and not upon an international standard. It is imperative to reach the goal of equal access to justice, which is a constitutional commandment and statutory imperative. Legal aid is not a charity or a chance, but as stated, it is constitutional mandate to the state and right of public, which is not now an opinion, but a constitutional obligation and compulsion. As such, it is not a pledge or a plan of a government, but has assumed the status of people's movement. Somebody has rightly said, what is the use of the system, which does not help lowly and lost, poor and downtrodden, and which creates distance between law and justice? It is in this context, the provisions for legal services have been made in the Constitution as well as in the Legal Services Authorities Act, 1987, over and above the provisions made in Section 304 of the Criminal Procedure Code, 1973. 2. Constitutional mandate. The state is under a constitutional mandate to provide free legal aid to an accused person who is unable to secure legal services on account of indigence, and whatever is necessary for this purpose has to be done by the state. The state may have its financial constraints and its priorities in expenditure, but, as pointed out by the court in Ream v. Malcolm 377 F. Sup. 995 The law does not permit any government to deprive its citizens of constitutional rights on a plan of poverty, and to quote the words of Justice Blackmun in Jackson v. Bishop 404 F sub 2d, 571 Human considerations and constitutional requirements are not in this day to be measured by dollar considerations. Khatri v. State of Bihar, A 1981 SC 928, 930. The founding fathers of the Constitution of India have right from the preamble taken a positive approach of doctrine of philosophy of equal justice, which becomes apparent on the plain perusal of the preamble of the Constitution. The preamble promise is further strengthened by the constitutional provisions in Articles 14, 19, 21, 22, 132, 39A, 51A and 226 of the Constitution of India. Article 22(1) of the Constitution expressly provides that no person who is arrested shall be detained in custody without being informed, as soon as may be, of the grounds for such arrest, nor shall he be denied of the right to consult and to be defended by a legal practitioner of his choice. Long before the Constitution, even in the old Criminal Procedure Code, under Section 341, it had been provided that any person accused of an offence before the criminal court or against whom proceedings are instituted under this code, or any such code, may of right be defended by a pleader. Free legal service is an essential element of fair procedure, when under Article 21 of the Constitution of India, no person can be deprived of his life or personal liberty except according to the procedure established by law. It is not enough that there should be some 24 semblance of procedure provided by law, but the procedure under which a person may be deprived of his life or liberty should be reasonable, fair and just. Menka Gandhi v. Union of India, A 1978 SC 597. Now, a procedure which does not make legal services available to an accused person who is too poor to afford a lawyer and who would, therefore, have to go through the trial without legal assistance, cannot possibly be regarded as reasonable, fair and just. It is an essential ingredient of reasonable, fair and just procedure to a prisoner who is to seek his liberation through the court's process that he should have legal services available to him. Insertion of Article 39A providing for equal justice and free legal aid is a principle of policy to be followed by the state. The Constitution 42nd Amendment Act, 1976 has inserted Article 39A as a directive principle of state policy. This article stipulates that 39A. Equal justice and free legal aid. The state shall secure that the operation of the legal system promotes justice, on the basis of equal opportunity and shall, in particular, provide free legal aid, by suitable legislation or schemes or in any other way, to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities, enforced W. E. F. 3.1.1977. This article, Article 39A, also emphasizes that free legal service is an inalienable element of reasonable, fair and just procedure, for without it a person suffering from economic or other disabilities would be deprived of the opportunity for securing justice. The right to free legal service is, therefore, clearly an essential ingredient of reasonable, fair and just procedure for a person accused of an offense, and it must be held implicit in the guarantee of Article 21. This is a constitutional right of every accused person who is unable to engage a lawyer and secure legal services on account of reasons such as poverty, indigence or incommunicado situation, and the state is under a mandate to provide a lawyer to an accused person if the circumstances of the case and the needs of justice so require, provided of course the accused person does not object to the provision of such lawyer. It is legal assistance to poor or indigent accused necessary sine qua non of justice, and where it is not provided, injustice is likely to result, and undeniably every act of injustice corrodes the foundations of democracy and rules of law, because nothing rankles more in the human heart than a feeling of injustice, and those who suffer and cannot get justice because they are priced out of the legal system, lose faith in the legal process, and a feeling begins to overtake them that democracy and rule of law are merely slogans or myths intended to perpetuate the domination of the rich and the powerful and to protect the establishment and the vested interests. In Khatri v. State of Bihar, A 1981 SC 928, the court went a step further and held that the constitutional obligation of the state to provide free legal service to an indigent accused extends not only at the stage of trial but also at the stage when he is first produced before the magistrate. However, in Sakh Das v. Union Territory of Arunachal Pradesh, A 1986 SC 991, 993, the Supreme Court further observed that, of course, it must be recognized that there may be cases involving offenses, such as economic offenses or offenses against law prohibiting prostitution or child abuse and the like, where social justice may require that legal service may not be provided by the state. 25. Exercise of this fundamental right, whether conditional upon the accused applying for free legal assistance, in Sukh Das v. Union Territory of Arunachal Pradesh, the Supreme Court, while interpreting legal aid as a fundamental right which the state is constitutionally obliged to provide to every indigent accused in criminal proceedings, dealt with the question whether this fundamental right could lawfully be denied to the accused if they did not apply for free legal aid. The court has observed, but the question is whether this fundamental right could lawfully be denied to the appellants if they did not apply for legal aid. Is the exercise of this fundamental right conditional upon the accused applying for free legal assistance, so that if he does not make an application for free legal assistance, the trial may lawfully proceed without adequate legal representation being afforded to him? Now, it is common knowledge that about 70% of the people living in rural areas are illiterate, and even more than that percentage of the people are not aware of the rights conferred upon them by law. Even literate people do not know what are their rights and entitlements under the law. It is this absence of legal awareness which is responsible for the deception, exploitation and deprivation of rights and benefits from which the poor suffer in this land. Their legal needs always stand to become crisis-oriented because their ignorance prevents them from anticipating legal troubles and approaching a lawyer for consultation and advice in time, and their poverty magnifies the impact of the legal troubles and difficulties when they come. Moreover, because of their ignorance and illiteracy, they cannot become self-reliant. They cannot even help themselves. The law ceases to be their protector because they do not know that they are entitled to the protection of law, and they can avail of the legal service program for putting an end to their exploitation and winning their rights. The result is that poverty becomes with them a condition of total helplessness. This miserable condition in which the poor find themselves can be alleviated to some extent by creating legal awareness amongst the poor. That is why it has always been recognized as one of the principal items of the program of the legal aid movement in the country to promote legal literacy. It would in these circumstances make a mockery of legal aid if it were to be left to a poor, ignorant and illiterate accused to ask for free legal service. Legal aid would become merely a paper promise, and it would fail its purpose. This is the reason why in Khatri v. State of Bihar A 1981 SC 928 we ruled that the magistrate or the sessions judge before whom an accused appears must be held to be under an obligation to inform the accused that if he is unable to engage the services of a lawyer on account of poverty or indigence, he is entitled to obtain free legal services at the cost of the state. Refer also to State of Kerala v. Kuttan, 1988 CRI LJ 453. In Khatri v. State of Bihar, the Supreme Court has held thus, but even this right to free legal services would be illusory for an indigent accused unless the magistrate or the sessions judge before whom he is produced informs him of such right. It is the common knowledge that about 70% of the people in the rural areas are illiterate, and even more than that percentage of people are not aware of the rights conferred upon them by law. There is so much lack of 26. Legal awareness that it has always been recognized as one of the principal items of the program of the legal aid movement in this country to promote legal literacy. It would make a mockery of legal aid if it were to be left to a poor, ignorant and illiterate accused to ask for free legal services. Legal aid would become merely a paper promise, and it would fail in its purpose. The magistrate or the sessions judge before whom the accused appears must be held to be under an obligation to inform the accused that if he is unable to engage the services of a lawyer on account of poverty or indigence, he is entitled to obtain free legal services at the cost of the state. Unfortunately, the judicial magistrate failed to discharge this obligation in the case of the blinded prisoners, and they merely stated that no legal representation was asked for by the blinded prisoners and hence none was provided. The Supreme Court in that case directed the magistrates and sessions judges in the country, we would, therefore, direct the magistrates and sessions judges in the country to inform every accused who appears before them and who is not represented by a lawyer on account of his poverty or indigence that he is entitled to free legal services at the cost of the state. Unless he is not willing to take advantage of the free legal services provided by the state, he must be provided legal representation at the cost of the state. The Supreme Court also directed the state of Bihar and required every other state in the country to make provision for grant of free legal services to an accused who is unable to engage a lawyer on account of reasons such as poverty, indigence or incommunicado situation. The only qualification would be that the offense charged against the accused is such that, on conviction, it would result in a sentence of imprisonment and is of such a nature that the circumstances of the case and the needs of social justice require that he should be given free legal representation. There may be cases involving offenses such as economic offenses or offenses against law prohibiting prostitution or child abuse and the like, where social justice may require that free legal services need not be provided by the state. Reports of Law Commission of India. Though even in the old Criminal Procedure Code, under Section 341, it had been provided that any person accused of an offence before the criminal court or against whom proceedings are instituted, under this code, or under any such code, may of right be defended by a pleader. Section 303 of the new code corresponds to the said section, with the addition of the words, of his choice, at the end. The emphasis being on, any person accused of an offence in a criminal case is entitled to be defended, as of right, by an advocate. This right under the said section did not make it obligatory on the part of the court in a sessions case, to assign a pleader for the defence of the accused at the expenses of the state. However, many high courts issued circulars and orders, and incorporated rules in the criminal rules of practice providing for assignment of an advocate for the defence of an 27 accused in session trials and other cases of serious nature in consonance with the constitutional mandate and fundamental human rights. Right to be provided with a lawyer by the state. For the first time it was in the year 1958, the Law Commission of India in its 14th report Volume 1 on the subject, Reform of Judicial Administration, made certain recommendations for state legal aid and emphasized for right to assignment of counsel at government expense. It observed, unless some provision is made for assisting the poor man for the payment of court fees and lawyers' fees and other incidental costs of litigation, she is denied equality in the opportunity to seek justice. p. 487. Again in 1969, the 41st Law Commission report, the Law Commission strongly recommended that representation by a lawyer should be made available at government expenses to accused persons in all cases tried by a Court of Sessions. Volume 1, Paras 24, 34-38. The Law Commission in its 48th report also suggested for making provision for free legal assistance by the state for all accused who were undefended by a lawyer for want of means. Recommendation codified in Section 30. This recommendation has now been codified in subsection 1 of Section 304 of the Code of Criminal Procedure, with this change made by the Joint Committee, that the state aid will be available only where the accused has not sufficient means to engage a pleader. Section 304 reads, 304. Legal aid to accused at state expenses in certain cases. 1. Where, in a trial before the Court of Session, the accused is not represented by a pleader, and where it appears to the court that the accused has not sufficient means to engage a pleader, the court shall assign a pleader for his defense at the expense of the state. 2. The High Court may, with the previous approval of the state government, make rules providing for the mode of selecting pleaders for defense under subsection 1. B. The facilities to be allowed to such pleaders by the courts. C. The fees payable to such pleaders by the government, and generally, for carrying out the purposes of subsection 1. 3. The state government may, by notification, direct that, as from such date as may be specified in the notification, the provisions of subsection 1 and 2 shall apply in relation to any class of trials before other courts in the state as they apply in relation to trials before courts of sessions. This section provides that when in the trial and more so in trials before the Court of Sessions, the accused is not represented by a pleader or an advocate, and when it appears to the court that the accused has not sufficient means to engage an advocate, the court shall assign a pleader or an advocate for his defense at the expense of the state. Under Section 304(3), the state government may, by notification, direct that the provisions of subsection 1 will apply to any class of trials before other courts in the state. 28. A bare reading of the provisions under Section 304 of the Criminal Procedure Code make it crystal clear that in a criminal trial, the magistrate or the sessions court before whom the accused appears must be held to be under an obligation to inform the accused that if he is unable to engage the services of a lawyer on account of poverty or indigence or any other disability, he is entitled to free legal services, at the cost of the state. It is, therefore, imperative for a presiding officer, in charge of a trial to inform every accused, who appears before him and who is not represented by a private lawyer on account of the poverty, ignorance or by any disability that he is entitled to free legal services, at the cost of the state. While it is settled position of law that to provide legal aid to accused persons without means in all cases tried by a court of session, is a mandatory constitutional necessity, it is further necessary that such lawyer should be of competence, Such counsel appointed for the accused must be given the complete brief of the case and time to prepare the case. Failure to this is a denial of proper representation of the accused and vitiates the trial. Raj Kishore v. State, 1969 Cre LJ 860 Cal A 1969 Cal 321. Also, no counsel can be thrust upon the accused without ascertaining the wishes of the accused and without giving him any choice in selecting his lawyer, as Article 22(1) of the Constitution guarantees that choice to be accused. Committee for Implementing Legal Aid Scheme (CILAS) concerned with the program of legal aid as it is the implementation of a constitutional mandate. In September 1980, the Government of India, with the object of providing free legal aid, by a resolution dated the 26th of September 1980, appointed Committee for Implementing Legal Aid Schemes (CILAS) with P.N. Bhagwati J. as he then was as the chairman to monitor and implement legal aid programs on a uniform basis in all the states and union territories. The committee evolved a model scheme for legal aid program, which includes organization of legal aid camps and set up several legal aid and advice boards throughout the country. But on a review of the working of the CILAS, certain deficiencies had come to the fore. It was, therefore, felt that it would be desirable to constitute statutory legal service authorities at the national, state and district levels so as to provide for the effective monitoring of legal aid programs. Therefore, the Legal Services Authorities Act, 1987 Act No. 39 of 1987 was enacted with a view to constitute legal services authorities at national, state and district levels. However, the Act not having been brought into force, the Act was brought into force with effect from the 9th of November 1995, almost 8 years after its enactment. The term of committee was extended again for a period of 1 year on and from the 14th of May 1990 until the National Legal Service Authority was constituted under the Legal Services Authorities Act, whichever was earlier. Constitution of legal aid boards and committees. Many states evolved their own programs and even enacted state legislation or promulgated certain schemes or rules to provide legal aid to underprivileged and disadvantaged sections of the society. For effective implementation and to achieve the desired objective of providing free legal aid and advice to the poor, state boards, district legal aid committees and taluka committees were constituted. But it was felt that enactment of a central legislation to coordinate and promote the activities of the various states in providing 29 legal aid and advice to the poor was desirable to monitor and implement legal aid programs on a uniform basis in all the states and union territories. Need for strategic legal aid program. It is now acknowledged throughout the country that the legal aid program which is needed for the purpose of reaching social justice to the people cannot afford to remain confined to the traditional or litigation-oriented legal aid program, but it must, taking into account the socio-economic conditions prevailing in the country, adopt a more dynamic posture and take within its sweep what we may call strategic legal aid program consisting of promotion of legal literacy, organization of legal aid camps, encouragement of public interest litigation and holding of lok adalats or niti melas for bringing about settlements of disputes whether pending in courts or outside. Center of Legal Research v. State of Kerala, A 1986 SC 2195. As observed by Justice Bhagawati. What is necessary is to supplement the traditional legal service program with strategic legal service program. The strategic legal service program aims at prevention and elimination of various kinds of injustices which the poor as a class suffer because of poverty and endeavors to launch a frontal attack on the poverty itself with the ultimate goal of its eradication from the society. It does not involve merely quantitative extension of traditional legal services to the poor but instead requires a qualitative and radical change in the whole emphasis, aims and functioning of the legal service program. It involves novel, radical, more dynamic and multi-dimensional uses of law in the legal process and seeks to provide representation to groups of social and economic protest. It does not regard litigation as playing an important or even significant role in the life of the poor and hence refuses to consider the court as a center of all legal activity and is concerned with the problems of the poor as a class rather than with the individual problems of the poor which may be projected in litigation in court. The strategic legal service program is thus directed towards group-oriented approach to the problem of poverty rather than individual-oriented treatment, and basically it is calculated to make the poor as class-conscious and powerful, self-reliant and capable of using law as a potent weapon for various purposes. A common man has started feeling that justice itself is on trial. It is, therefore, imperative to evolve effective and efficient strategies, both preventive and protective. 1. To manage, unmanageable. 2. To break, unbreakable. 3. To beat, unbeatable. 4. To hit, unhittable. 5. To defend, indefensible. Looking to the present situation in the country, we are obliged to create and constitute a neo-jurisprudence, a public-oriented participation performing, progressive, professional and pervasive programs. Unfortunately, in the present system, the litigant, who is the heart of judicial anatomy, is the most neglected segment. He is the consumer of justice and he should be respected. The litigant, consumer of justice and heart of our system, must receive equal, effective, inexpensive and speedy trial and justice. In our country, amount spent or expenditure for administration of law and justice is reported 0.2% of the gross domestic product (GDP), which is grossly inadequate and insufficient in a democratic setup. It is, therefore, necessary to constitute a regular mechanism, whereby we can take and evaluate judicial cardiogram for necessary urgent and 30 useful, effective and ebullient reforms to translate constitutional mandate and obligation propounded right from preamble promise in their fighting faith by its founding fathers, a reality. Legal literacy. Legal literacy is a precondition to maintain the rule of law. As observed by Justice Bhagwati, the strategic legal service consists of creating legal awareness, or what may be described as promoting legal literacy, for knowledge of their rights and entitlement would give to the poor strength and confidence to fight and help them to avoid needless difficulties which arise from ignorance. Legal aid camps can also be arranged as part of the strategic legal service program for carrying legal services to the doorsteps of the rural poor. Quoted in Equal Justice and Forensic Process, Truth and Myth, by V.R. Krishna Iyer, at p. 47. The model scheme for legal aid evolved by the Committee for Implementing Legal Aid Scheme (CILAS) also included program for promotion of legal literacy and spread of legal awareness among the weaker sections of the community by way of organizing legal aid camps, especially in rural areas, slums or labor colonies. Voluntary organizations, social action groups, journalists and even advocates have been rendering significant service to educate the people about the laws, their rights and benefits flowing out of the various schemes and measures. The assistance of voluntary agencies and social action groups must therefore be taken by the state for the purpose of operating the legal aid program in its widest and most comprehensive sense, and this is an obligation which flows directly from Article 39A of the Constitution. Public interest litigation. Public interest litigation has been devised as a tool to secure benefit to a class or group of persons, either victims of exploitation or oppression, or who are denied the constitutional rights but cannot come to court personally for relief by reason of ignorance, poverty, destitution, helplessness, disability or social or economic disadvantage. It is a form of litigation where jurisdiction of the court is invoked on behalf of such persons or group of persons by a third person or a social action group or a social organization regardless of its personal injury. Cases of this kind involve the rights of thousands of people at a time, unlike traditional litigation, which are basically of adversary character and concerns disputes between individuals. Whenever such litigations have come to court, the courts in the country have done everything to help the poor and to break every procedural barrier to deliver justice to the poor. To quote Krishna Iyer, molding the remedies to suit the needs of the situation so that efficacious and comprehensive remedies may be granted, regardless of pickled precedents in remedial methodology, is part of judicial dynamics. Public interest litigation, which is a strategic arm of the legal aid movement and which is intended to bring justice within the reach of the poor masses, who constitute the low visibility area of humanity, is a totally different kind of litigation from the ordinary traditional litigation, which is essentially of an adversary character where there is a dispute between two litigating parties, one making claim or resisting such relief. Public interest litigation is brought before the court not for the purpose of enforcing the right of one individual against another as happens in the case of ordinary litigation, but it is intended to promote and vindicate public 31. Interest, which demands that violation of constitutional or legal rights of large number of people who are poor, ignorant or in a socially or economically disadvantaged position should not go unnoticed and unredressed. That would be destructive of the rule of law, which forms one of the essential elements of public interest in any democratic form of government. The rule of law does not mean that the protection of the law must be available only to a fortunate few or that the law should be allowed to be prostituted by the vested interests for protecting and upholding the status quo under the guise of enforcement of their civil and political rights. The poor too have civil and political rights and the rule of law meant for them also, though today it exists only on paper and not in reality. People's Union for Democratic Rights v. Union of India, A 1982 SC 1473. Public interest litigation is essentially a cooperative or collaborative effort on the part of the petitioner, the state or public authority and the court to secure observance of the constitutional or legal rights, benefits and privileges conferred upon the vulnerable sections of the community and to reach social justice to them. So far the courts have been used only for the purpose of vindicating the rights of the wealthy and the affluent. It is only these privileged classes which have been able to approach the courts for protecting their vested interests. It is only the moneyed who have so far had the golden key to unlock the doors of justice. But, now for the first time the portals of the court are being thrown open to the poor and the downtrodden, the ignorant and the illiterate, and their cases are coming before the courts through public interest litigation, which has been made possible by the recent judgment delivered by the Supreme Court in S.P. Gupta v. President of India, A 1982 SC 149 Judges Appointment and Transfer Case. The legal aid movement and public interest litigation seek to bring justice to these forgotten specimens of humanity who constitute the bulk of the citizens of India and who are really and truly the people of India, who gave to themselves this magnificent constitution. It is true that there are large arrears pending in the courts, but that cannot be any reason for denying access to justice to the poor and weaker sections of the community. No state has a right to tell its citizens that because a large number of cases of the rich and the well-to-do are pending in our courts, we will not help the poor to come to the courts for seeking justice until the staggering load of cases of people who can afford is disposed of. The time has now come when the courts must become the courts for the poor and struggling masses of the country. They must shed their character as upholders of established order and the status quo. They must be sensitized to the need of doing justice to the large masses of people to whom justice has been denied by a cruel and heartless society for generations. The realization must come to them that social justice is the signature tune of our Constitution, and it is their solemn duty under the Constitution to enforce the basic human rights of the poor and vulnerable sections of the community and actively help in the realization of the constitutional goals. This new change has to come if the judicial system is to become an effective instrument of social justice, for without it, it cannot survive for long. Fortunately, this change is gradually taking place and public interest litigation is playing a large part in bringing about this change. It is through public interest litigation that the problems of the poor are now coming to the forefront and the entire theatre of the law is changing. It holds our great possibilities for the future. In M.C. Mehta v. Union of India, A 1987 SC 1086, a constitutional bench of the Apex 32 Court, while considering the scope of public interest litigation to grant compensation to the victims of hazardous or dangerous activities when deaths or injuries were caused to them on account of the accident during the operation of such activities, has held that the law should keep pace with changing socio-economic norms. Where a law of the past does not fit in the present context, the court should evolve new law in a public interest litigation. The court has incidental and ancillary powers in exercise of which it can devise new methods and strategy in securing enforcement of fundamental rights, particularly in public interest litigation or social action cases. In Bandhava Mukti Morcha v. Union of India, A 1984 SC 802, 815, the Supreme Court held that when the poor come before the court, particularly for enforcement of their fundamental rights, it is necessary to depart from the adversarial procedure and to evolve a new procedure which will make it possible for the poor and the weak to bring the necessary material before the court for the purpose of securing enforcement of their fundamental rights. The Supreme Court further observed, it must be remembered that the problems of the poor which are now coming before the court are qualitatively different from those which have hitherto occupied the attention of the court, and they need a different kind of lawyering skill and different kind of judicial approach. If we blindly follow the adversarial procedure in their case, they would never be able to enforce their fundamental rights and the result would be nothing but a mockery of the Constitution. We therefore to abandon the laissez-faire, let things be approach in the judicial process, particularly where it involves a question of enforcement of fundamental rights, and forge new tools, devise new methods and adopt new strategies for the purpose of making fundamental rights meaningful for the large masses of the people. And this is clearly made permissible by the language of Clause 2 of Article 32, because the Constitution makers, while enacting that clause, have deliberately and advisedly not used any words restricting the power of the court to adopt any procedure which it considers appropriate in the circumstances of a given case for enforcing the fundamental right. It is true that the adoption of this non-traditional approach is not likely to find easy acceptance from the generality of lawyers because their minds are conditioned by constant association with the existing system of administration of justice, which has become ingrained in them as a result of long years of familiarity and experience and become part of their mental makeup and habit, and they would therefore always have an unconscious predilection for the prevailing system of administration of justice. But if we want the fundamental rights to become a living reality and the Supreme Court to become a real sentinel on the qui-vive, we must free ourselves from the shackles of outdated and outmoded assumptions and bring to bear on the subject fresh outlook and original unconventional thinking. The traditional rule of locus standi considerably relaxed by the Supreme Court. The traditional rule in regard to locus standi, that judicial redress is available only to a person who has suffered a legal injury by reason of violation of his legal rights by some agency or individual, has now been considerably relaxed by the Supreme Court. In SP Gupta 33. We. President of India, A 1982 SC 149, 188, the Supreme Court speaking through Bhagwati, J. has held, it may, therefore, now be taken as well established that where a legal wrong or legal injury is caused to a person or to a determinate class of persons by reason of violation of any constitutional or legal right, or any burden is imposed in contravention of any constitutional or legal provision, or without authority of law, or any such legal wrong or legal injury or illegal burden is threatened, and such person or determinate class of persons is by reason of poverty, helplessness, or disability, or socially or economically disadvantaged position, unable to approach the court for relief, any member of the public can maintain an application for an appropriate direction, order a writ in the High Court under Article 226, and in case of breach of any fundamental rights of such person or persons, in this court, Supreme Court, under Article 32, seeking judicial redress for the legal wrong or injury caused to such person or determinate class of persons. The institution of Lok Adalat. Lok Adalats or Niti Melis Lok Adalat has emerged lately as a new system of dispensation of justice and received tremendous response and wide support from different sections of the society. The system, visualized as an alternative dispute settlement mechanism, evolved as a part of the CILAS program with the object of taking justice to the doorsteps of the poor and to give speedy and cheap justice to those who cannot afford to fight the costly legal battle. Lok Adalat has come to be seen as an institution or an agency for handling disputes by conciliation and counseling, a species of peacemaking. Lok Adalats do not treat the issues before it is disputes under contest and decide cases, but treat them as differences and resolve them by conciliatory and persuasive efforts. The process involves discussing with the parties the pros and cons of their case and explaining to them advantages and disadvantages of resolving their dispute by conciliation and compromise, or in the alternative, of resorting to the traditional dilatory procedure of adversarial litigation in regular courts. The process of participatory justice is a unique feature of this institution. Dispute in the Lok Adalats is resolved by discussion in an informal atmosphere, in which parties and panel members of the Lok Adalat participate, and settlement is reached with the mutual and free consent of the parties. Unlike in litigations concluded in our regular courts, being in the nature of compromises, there is no winner and no loser in a mediated resolution of dispute by Lok Adalats. The intention being to help warring parties to work things out, shake hands, and become friends or not enemies again. Resolution of disputes in Lok Adalat is more likely to bring or keep people together and, therefore, more conducive to harmonies. There has been in the last few years a growing interest in the institution, and it has emerged as a forum for alternative dispute resolution to supplement the existing justice delivery system. These forums, based on the concept of dispute settlement mechanism by way of counseling, persuasion and conciliation, function as peacemaker, and are intended to work informally with simplified procedure. As part of CILAS program, Lok Adalats People's Court were constituted and 90 melis were organized at various places in the country, under the supervision of State Legal 34. Aid and advice boards, for the disposal, in a summary way and through the process of arbitration and settlement between the parties, of a large number of cases expeditiously and with lesser costs. The organizers of the Lok Adalats fixed the date and place of the holding of Lok Adalats about a month in advance. Information about the holding of Lok Adalat was widely publicized through press and other means of publicity. Presiding officers of various courts were requested to look into the cases pending in their respective courts and to see whether there was possibility of conciliation in these cases. Such of those cases where there was reasonable possibility of conciliation were identified and listed. Cases were analyzed, classified under various heads according to the nature of dispute and substance recorded. Then, pre-Lok Adalat conferences were held and parties to the dispute were approached and motivated by the legal aid teams, which included law students, social workers and volunteers to resolve their disputes through Lok Adalats. Before the case was taken up by the Lok Adalat, the mediation process or justice process through Lok Adalat was initiated by way of thorough discussion with the parties as to the details of the case and desirability of conciliation and compromise, and the scope of a settlement mutually acceptable to the parties was assessed. The team involved in the mediation or Lok Adalat justice process consisted of the members of local legal aid committee, advocates, spirited public men or elders of the locality or social activists and called conciliators. This process was continued and resumed at the campsite of the Lok Adalat. Once parties had made a compromise or arrived at a settlement, it was reduced into writing by members of the panel of the Lok Adalat. Signatures of the parties were obtained and countersigned by the members of the panel and passed on to the court concerned for final decree or order. Multiple panels, according to the need of the Lok Adalat, were set up. These panels or members of Lok Adalat consisted of 2 or 3 persons. One of them could be a retired judge or a senior retired civil servant or an advocate, a law teacher, and others, social workers and eminent persons of the locality, carefully chosen by the local aid committees on the basis of their record of public services, honesty and respectability among local population, supposed to be good conciliators, concerned with the cause of social justice and sympathetic to people's problem. When the compromise so arrived at was presented before the court concerned, the court was expected to look into the question whether all the parties to the suit were entering into settlement or compromise, examine the fairness and legality of the settlement or compromise, and satisfy itself that compromise had been arrived at by free and mutual consent of the parties. After this process of due verification of the compromise made or settlement arrived at by the parties, decree or orders were passed in terms of the settlement or compromise. Importance of the institution of Lok Adalat in the present context. The revolutionary evolution of resolution of dispute by one or other means, alternate dispute redressal ADR mechanism, has been successfully translated in various countries. While, in India, roughly 91% of cases instituted in the courts go for trial and only 9% of cases are settled without judicial agitation, in USA, more than 90% of cases involving legal disputes are settled before they go for trial. The institution of Lok Adalat has been acknowledged as an effective alternate dispute redressal agency and gaining wide acceptability. More and more people are choosing this forum to help settlement of dispute through negotiation, counseling, conciliation, settlement 35, and compromise than to go for a verdict through court. It provides a quicker remedy, it is less expensive, less time consuming, does not permit dilatory tactics of parties to prolong litigation. It saves parties from intricacies of procedure and is concerned more with narrowing the differences and finding settlement in accordance with natural justice, rules of equity and other legal principles than with expatiating upon procedural complexities and their strict application. It is based on jurisprudence of peace and provides a rendezvous for social amity and affinity and social justice. It aims at promoting larger interest, harmony, comity and policy and jurisprudential cohesion and environment. Looking to the present situation in the country, the role of Lok Adalat assumes higher degree of importance. It is reported that 34% of the total world's poor populace is in India. More than majority persons live below poverty line. Most of the rural people in India who reside in more than 518,000 villages are either illiterate, indigent or ignorant of their rights. Even in case of urban populace, most of them are ignorant about their legal rights, who are otherwise literate. The urbanized populace lack awareness about their legal rights. Our present traditional system of justice is suffering from maladies like huge and heavy expenses, unexpected and unpredictable delay in disposal and cumbersome and complex process of court. In view of the failure to provide easy, cheap and expeditious accessibility, mental barrier is developed amongst many persons to suffer injustice. As a result of which, a common man has started looking at it as foe rather than a friend. The lifespan of a civil case or a lawsuit in civil side is ranging average between 8 to 12 years. Who knows, even after a successful decision or order in favor of a party, whether he would be able to see light at the end of tunnel after having passed through the long legal and procedural conduit pipes. Even after a decree awarded or order passed on judicial side in favor of a party, after number of years, successful party has to again undergo the second round of litigation at the stage of execution. It is not a pity v. duty. Pending workload of cases in Indian courts has rapidly crossed the 30 millions as per latest survey, and many more are under inquiry or investigation stage, etc. The ratio of judges per million in India is almost 9, whereas it is more than 115 in USA. In case of ratio of advocate available in India, is far less than developed countries. There are about only 450,000 and odd number of advocates in India, which has populace of 1 billion. In view of these circumstances, the institution of Lok Adalat is being looked upon as an effective alternate dispute redressal forum, which has proved to be dialectical and speedy. By bringing justice at their doorstep, it gets the poor litigants justice without having to meet huge costs and help them to settle their disputes amicable. It creates not only peace but also a culture of compromise. It provides a rendezvous for social amity and affinity and social justice. Cf. Dinesh Bhai Dhemon Raivi. State of Gujarat, 2001, 1 GLR 603. Legal status for Lok Adalat. The Lok Adalat, a species of conciliatory agency, proved to be very popular in providing for a speedier system of administration of justice at lesser costs. The success of these Lok Adalats in taking justice to the doorsteps of poor and the needy and making justice quicker and less expensive raised a new ray of hope for those who could not otherwise afford to fight the protracted costly legal battle for assertion and protection of their rights under the law. The institution received wide support from concerned citizens and spread to disputes of diverse and varied nature and resolved cases pertaining to compoundable criminal complaints, civil and revenue disputes, MACT cases, and even institutional cases 36. Cases where one of the parties is an institution, such as municipality or a corporation. The number of cases resolved by these Lok Adalats also began to reflect on the workload of our regular courts. The institution of Lok Adalats was, however, functioning as a voluntary agency without any statutory backing for its decisions. In view of its growing popularity, there was demand for providing a statutory backing to this institution and the awards given by Lok Adalats. It was being felt that such a statutory support would not only reduce the burden of arrears of work in regular courts, but would also provide social justice and serve to achieve the constitutional mandate under Article 39A. The government was convinced that this admirable alternate dispute settlement mechanism shall not only reduce the burden of arrears of work in regular courts, but would also take justice to the doorsteps of the poor and the needy and make justice quicker and less expensive, and felt that if the Lok Adalats were given statutory status they could function more effectively. Therefore, the government, in exercise of its duty under Article 39A, drafted the Legal Services Authorities Bill 1987, and the same was enacted by the Parliament as Act No. 39 of 1987, acknowledging the institution of Lok Adalat and giving statutory status to Lok Adalats. However, the Act was brought into force with effect from the 9th of November 1995, almost 8 years after its enactment. Public participation in legal aid program, role of voluntary organizations and social action groups, in Center of Legal Research v. State of Kerala, A 1986 SC 2195, the Supreme Court held that there could be no doubt that if the legal aid program was to succeed it must involve public participation. The court observed, the state government undoubtedly has an obligation under Article 39A of the Constitution, which embodies a directive principle of state policy, to set up a comprehensive and effective legal aid program in order to ensure that the operation of the legal system promotes justice on the basis of equality. But we have no doubt that despite the sense of social commitment which animates many of our officers in the administration, it is absolutely essential that people should be involved in the legal aid program, because the legal aid program is not charity or bounty, but it is a social entitlement of the people, and those in need of legal assistance cannot be looked upon as mere beneficiaries of the legal aid program, but they should be regarded as participants in it. Emphasizing the importance of role that could be played by voluntary organizations and social action groups in securing people's participation and involvement in the legal aid program, the Supreme Court went on to observe, if we want to secure people's participation and involvement in the legal aid program, we think the best way of securing it is to operate through voluntary organizations and social action groups. These organizations are working amongst the deprived and vulnerable sections of the community at the grassroots level, and they know what are the problems and difficulties encountered by these neglected sections of the Indian humanity. They have their finger on the pulse of the people, and they know from their own experiences to what are the unmet legal needs of the people, what are the sources of exploitation and injustice to the underprivileged segments of 37. Society, and what measures are necessary to be taken for the purpose of ending such exploitation and injustice and reaching social or distributive justice to them. We are therefore definitely of the view that voluntary organizations and social action groups must be encouraged and supported by the state in operating the legal aid program. It is now acknowledged throughout the country that the legal aid program which is needed for the purpose of reaching social justice to the people cannot afford to remain confined to the traditional or litigation-oriented legal aid program, but it must, taking into account the socio-economic conditions prevailing in the country, adopt a more dynamic posture and take within its sweep what we may call strategic legal aid program consisting of promotion of legal literacy, organization of legal aid camps, encouragement of public interest litigation and holding of lok adalats or niti melas for bringing about settlements of disputes whether pending in courts or outside. The assistance of voluntary agencies and social action groups must therefore be taken by the state for the purpose of operating the legal aid program in its widest and most comprehensive sense, and this is an obligation which flows directly from Article 39A of the Constitution. Role of the bench and the bar. In various countries, particularly in United States and other Western countries, the contribution of the bar in rendering free and competent legal aid is praiseworthy and it must be emulated. Legal aid fraternity must respond with juristic sensitivity to the voice from the silence zone, a class of litigants, and mass voice of weak, meek, poor, suppressed and exploited women and destitute children so as to create evolving ebullient echo for the silent sector. The bar must evolve scheme to ensure that unprotected is not priced out of market. The bar is, really, a backbone of the legal services to complement and complete the constitutional obligation and obtain statutory rights of millions of indigent, needy, handicapped and deserving people. To save the nation, a catalytic role has to be played by legal aid in the larger interest of weaker sections. NALSA has undertaken various important and effective and appreciable legal aid programs and, therefore, members of bench and bar, NGOs, and government agencies must render voluntary helping hand in such noble and novel projects. See Dinesh Bhai Dhemon Raivi. State of Gujarat, 2001, 1 GLR 603. 38. Rule of Law. Constitution of India, Article 14. Equality before law. The state shall not deny to any person equality before law or equal protection of laws within the territory of India. Dicey's rule of law. Dicey said, it means, in the first place, the absolute supremacy or predominance of regular law is opposed to the influence of arbitrary power, and excludes the existence of arbitrariness, of prerogative, or even of wide discretionary authority on the part of the government. Englishmen are ruled by the law, and by the law alone. A man may with us be punished for a breach of law, but he can be punished for nothing else. It means, again, equality before the law, or the equal subjection of all classes to the ordinary law courts. The rule of law, in this sense, excludes the idea of any exemption of officials or others from the duty of obedience to the law which governs other citizens or from the jurisdiction of the ordinary tribunals. There can be with us nothing really corresponding to the administrative law, droit administratif, or the administrative tribunals, tribunaux administratifs of France. The notion which lies at the bottom of the administrative law, known to foreign countries as that affairs or disputes in which the government or its servants are concerned are beyond the sphere of the civil courts and must be dealt with by special and more or less official bodies. This idea is utterly unknown to the law of England, and indeed is fundamentally inconsistent with our traditions and customs. According to Dicey, the rule of law, as he formulated it, was a principle of the English Constitution. The preface to the first edition says that the book deals with only 2 or 3 guiding principles which pervade the modern Constitution of England, and the book shows that the rule of law is one such principle. This is important, for the modern version of that rule does not assert that it is a principle of the English Constitution, but that the rule is an ideal by reference to which that Constitution must be judged. Dicey's rule of law has been criticized by eminent writers. I will, however, make certain observations about Dicey's rule of law which would be generally accepted today. A. Dicey wrote in the heyday of laissez-faire and he dealt with the rights of individuals, not with the powers of the administration. B. It is tempting to say that the welfare state has changed public law, and consequently delegated legislation and the exercise of judicial functions by administrative bodies have increased. But the true view is that Dicey's rule of law, which was founded on The H.M. Sirvai, the Supreme Court of India and the shadow of Dicey in the position of the judiciary under the Constitution of India, pp. 83-96 1970. A. V. Dicey, Law of the Constitution 1885. 39. Separation of powers, fixed public attention on administrative law and delegated legislation. Dicey dealt with individual liberty and criticized administrative discretion. But he did not deal with the administration as such, and he failed to distinguish between discretion given to public officials by statute and the arbitrary discretion at one time claimed by the king. See, administrative law existed in England when Dicey's book was published in 1885. The prophetic vision of Maitland saw in 1887 that even as a matter of strict law it was not true the executive power was vested in the king. England, he said, was ruled by means of statutory powers which could not be described as the powers of the king. All that we could say was that the king had powers, this minister had powers, and that minister had powers. In oft-quoted words, Maitland said that England was becoming a much-governed nation, governed by all manner of councils and boards and officers, central and local, high and low, exercising the powers which had been committed to them by modern statutes. And Prof. Wade has come to the same conclusion in his appendix to the 9th edition of Dicey's Law of the Constitution. In his Law of the Constitution, Dicey did not refer to the prerogative writs of mandamus, prohibition and certiorari by which superior courts exercised control over administrative action and adjudication. These writs belong to public law and have nothing to do with private law, and had he noticed those writs he could not have denied the existence of administrative law in England. Dicey's picture of the Englishman protected by the rule of law, and the Frenchman deprived of that protection because public authorities in France enjoyed privileges and immunities is now recognized as a distorted picture. This recognition is not confined to academic lawyers. An eminent judge, Lord Denning, has said that far from granting privileges and immunities to public authorities, the French administrative courts exercise a supervision and control over public authorities which is more complete than which the courts exercise in England. And that is also the view of leading writers on constitutional and administrative law today. Dicey himself showed a change of heart in his long introduction to the 8th edition of the Law of the Constitution. There, he doubted whether law courts were in all cases best suited to adjudicate upon the mistakes or the offenses of civil servants, and he said that it was for consideration whether a body of men who combined legal knowledge with official experience, and who were independent of government, would not enforce official law more effectively than the High Court. It is a measure of Dicey's intellectual integrity that he abandoned the doctrine of a lifetime and recognized official law, and a special tribunal substantially on the lines of the Council D. 8 as better suited to enforce that law than the High Court. It is unfortunate that Dicey did not rewrite the book in the 8th edition, but contented himself with a long introduction which marked a real change in his thinking. The text remained unchanged, and the introduction was forgotten or ignored, so that an intemperate judge like Lord Hewitt LCJ could speak of the abominable doctrine that, because things are done by officials, therefore some immunity must be extended to them. 40. Coming from a Lord Chief Justice, these words seem ironic, for, on grounds of public policy, the most malicious words of judges of superior courts in the discharge of their judicial duties enjoy absolute immunity. But Lord Hewitt would have been shocked had anyone spoken of the abominable doctrine that because things are done by judges in their judicial capacity, therefore, some immunity must be extended to their most malicious words. When Dicey maintained that the rule of law required the equal subjection of all classes to the ordinary law of the land administered by ordinary courts, and that the rule of law was inconsistent with administrative law and administrative tribunals, he created a false opposition between ordinary and special law, and between ordinary courts and special tribunals. The two kinds of laws existed even in his day, and ordinary courts, as well as special tribunals, determined the rights of parties. His antithesis was false in fact and untenable in principle. A law administered by the courts and by special tribunals is equally the law of the land. The determinations of courts and of special tribunals are determinations under the law. As we have seen, Dicey himself came to recognize that it may be necessary to create a body of persons for adjudicating upon the offenses or the errors of civil servants as such adjudication may be more effective in enforcing official law. This effectively destroyed the opposition between ordinary law administered by ordinary courts and special law administered by special tribunals. As Devlin J. speaking of England, put it, it does not matter where the law comes from, whether from equity, or common law or from some sources yet untapped. And it is equally immaterial whether the law is made by Parliament, or by judges or even by ministers, for what matters is the law of England. That courts alone are not the best agencies for resolving disputes is shown by the history of the commercial court in England. When it was established, it first proved popular and succeeded in arresting the trend in favor of arbitration. After the First World War, 2 judges were sitting full-time on the commercial list. In 1957, out of 26 cases only 16 were actually tried, the rest being stayed, withdrawn or settled, and the question arose whether there was any point in retaining the commercial court. In 1960, the Lord Chancellor took an unusual step. He called a commercial court users conference. The conference presented a report which is important because it shows why people preferred arbitration to adjudication by the commercial court. Mr. Justice Mego, who was appointed to the commercial court, gave a practice direction which went back to an earlier and simpler procedure. The calling of the Commercial Users Conference, and the emphasis in the practice direction on the service which the court rendered, is a timely reminder that judicial power is not property which belongs to the law courts and which therefore can be usurped by others, but that judicial power exists to render a service, and if the service is not good enough, it will be ignored. Prof. Robson has given an even more striking example. Before the Committee on Ministers' Powers, evidence was given by the National Federation of Property Owners and Ratepayers representing the owners of more than £1,000 million capital invested in industrial, 41, trading and residential property throughout the United Kingdom. The Federation demanded that the appellate jurisdiction of ministers and their departments should cease. But the Federation did not demand the transfer of such jurisdiction to ordinary courts of law but to a special tribunal consisting of a full-time salaried legal member appointed by the Lord Chancellor, and two part-time honorary members who could bring administrative experience to bear on administrative matters. The Federation also suggested that the special tribunal should also take over the jurisdiction of the country court judges and the courts of summary jurisdiction in respect of appeals from the decisions, acts or orders of local authorities, and appeal from the special tribunal being permitted only on points of law. When Dicey said that wide discretionary authority was inconsistent with the rule of law, he might have expressed his political philosophy, but he certainly did not express a principle of the English Constitution, for in fact wide discretionary power existed in England. A leading modern textbook on English constitutional law observes that if it is contrary to the rule of law that discretionary authority should be given to government departments or public officers, then the rule of law is inapplicable to any modern constitution. Dicey's dislike of discretionary power was due, first, to the fear of abuse, and, secondly, to the belief that the judicial function consists in applying settled principles of law to the facts of a case, and not in the exercise of discretionary power. Taking the second point first, the exercise of discretionary power formed then, and forms now, a large part of the work of regular courts. Thus, where an accused pleads guilty, the only question which remains is one of punishment, and here the judge has a very wide discretion. Again, if discretion is opposed to the rule of law, a final court with discretionary power to admit or reject an appeal or an application would contravene the rule of law, and yet most final courts, including a Supreme Court, possess this power, and, what is more, exercise it without assigning any reasons. Again, the power to adjourn a case, to allow an amendment, to condone delay, to award costs are discretionary powers, and like all discretionary powers may be abused. But the law confers all necessary discretionary powers notwithstanding the possibility of abuse, though it is usual to provide safeguards against abuse. But the safeguards are not always effective. When High Court judges say, as I have heard them say, we prefer to be wrong, you can go to the Supreme Court after obtaining special leave from it, judicial power is abused, and the safeguard of an appeal nullified in a practical sense, for an appeal by special leave is expensive, and if the amount at stake is small, few persons will spend thousands of rupees to set right a palpably wrong decision. Nor is it enough to say that the judge is independent and an administrative tribunal is not. First, there is no reason why an administrative tribunal cannot be made independent of government. Secondly, in England, judges of the superior courts are practically irremovable, but judges of subordinate courts can be removed by the Lord Chancellor for inability or misbehavior, and justices of the peace, who are an essential part of the administration of justice, can be removed by the Lord Chancellor at pleasure. Again, though in theory, the members of the Conseil d'État in France are removable by the executive, in practice no member has been removed for rendering judgments unpalatable to 42. The government, though many such judgments have been rendered. The ultimate guarantee against abuse of power, legislative, judicial and executive, lies in the political and legal safeguards against such abuse, in a vigilant public opinion, and in a sense of justice in the people generally. The emphasis which Dicey laid on personal freedom from arbitrary arrest and detention is as true, if not more true, as when Dicey wrote his book. Dicey's doctrine that all classes in the United Kingdom were subject equally to the ordinary law of the land administered by the ordinary courts was true in the very limited sense that a public servant was individually liable for a tort or a crime. But equality before the law did not mean equality of rights and duties. An unpaid tax is a debt due to the state, but the income tax authorities have powers for recovering that debt which private creditors do not have for the recovery of their debts. I said earlier that Dicey asserted that his rule of law was a principle of the Constitution. The modern version of the rule of law takes a different line. In a well-known book on constitutional law, it is said that the rule of law demands the payment of compensation in certain circumstances where a person is injured by a change in the law. Discretionary power should not be arbitrary power. You will notice that this view does not assert that the rule of law is a principle of the English Constitution, and in fact it is not. The rule of law thus formulated belongs to the realm of political and moral philosophy, and can be accepted or rejected according as one accepts or rejects that philosophy. The rule of law becomes a banner under which opposing armies march to combat, says one leading textbook on administrative law. The rule of law, which is a fine sonorous phrase, can now be put alongside the brotherhood of man, human rights and all the other slogans of mankind on the march, says Prof. Jackson. And he rightly observes that the doctrines of the separation of powers and the rule of law give little help in determining the practical question, what matters should be assigned to special tribunals and what to courts of law. Speaking for the Privy Council, Lord Atkin formulated that concept in the following oft-quoted words. As the executive, he, i.e. the governor, can only act in pursuance of the powers given to him by law. In accordance with British jurisprudence, no member of the executive can interfere with the liberty or property of a British subject except on the condition that he can support the legality of his action before a court of justice. And this passage has been cited and followed by our Supreme Court. Is the above discussion merely theoretical? I think not, if we consider Nanavati case and Bharat Singh case in the light of that discussion. Nanavati case involved no question about Dicey's rule of law, or even of the rule of law, because the governor did not claim the power to act without the authority of law. The question was whether the suspension of Nanavati's sentence by the governor under Art. 161, which expressly conferred on him the 43 power to grant reprieve or respite, was valid in law. The majority held that it was not, because according to the majority the power of the governor did not extend to suspending the sentence after the Supreme Court had admitted an appeal from it. Sinha, CJ observed that to uphold the power of the governor to suspend the sentence would involve a conflict between the executive and the judiciary, for an order of the Supreme Court releasing an accused on a bail of Rs. 10,000 could be nullified by obtaining a simple order of suspension from the governor. Avoidance of such a possible conflict will incidentally prevent any invasion of the rule of law, which is the very foundation of our Constitution. Here you have the distracting influence of the emotional and political overtones of Dicey's rule of law, and of the doctrine of the separation of powers, from which it is easy to slip unconsciously into the belief that judicial power is property. I say, unconsciously, because judges may be quite unaware that they are treating judicial power as property. If this appears to be a fancy of my own, let me give you a delightful passage from Prof. Robson. Discussing Prof. Morgan's remark that the acquisition of judicial functions by the executive was all the more unwarrantable, because courts of law had not in their turn encroached on the functions of the executive, Prof. Robson said. Prof. Morgan writes as though the executive and the judiciary were riparian owners bargaining over a strip of land, a European power is carving up an African colony. And he adds, neither the executive nor the judiciary has any immutable right to a particular province. Applying this to Nanavati case, if judicial power were property, the release of a convicted person on a bail of Rs. 10,000 would be legal exercise of a right of property, and the nullification of that order by the governor's reprieve would violate a legal right and thus appear to be against the rule of law. But if we lay aside Dicey and the separation of powers, it is clear that Nanavati case raised no question of the rule of law. Judicial power to try and punish an accused person and the executive power to exercise clemency and to pardon the accused, or to commute or remit his punishment, or to suspend his sentence by a reprieve or respite, is part of our constitutional scheme. The power to pardon, said Taft CJ, exists to ameliorate or avoid particular criminal judgments. It is a check entrusted to the executive for special purposes. It requires no argument to show that occasionally miscarriage of justice does take place. That occasionally a judge enters the arena of conflict and his vision is blinded by the dust of controversy. Among other reasons, the power of pardon exists to remedy the miscarriage of justice or to remedy the consequence of human failings in a judge. Such miscarriage can take place in passing a sentence of death. It can take place equally in keeping an appellant in prison by refusing him 44 bail. If, as the Supreme Court admits, the rule of law is not violated if the sentence of death is in effect wiped out by a free pardon, surely it is fanciful to say that the rule of law is violated if release on a bail of Rs. 10,000 by a court is wiped out by a reprieve or respite which suspends the sentence. The rule of law, like the name of God, can sometimes be invoked in vain. The State of MP vs. Bharat Singh A 1967 SC 1170 also did not raise any question about Dicey's rule of law, though it did raise a question about the rule of law in the strict legal sense. In Bharat Singh case, it was contended that as the executive power of the state was coextensive with its legislative power, an executive order restricting the movements of a citizen could be passed without the authority of any law, and the Supreme Court's decision in Kapoor case Ram Javed Kapoor v. State of Punjab 19552 SCR 225 was relied upon to support the contention. The Supreme Court could have pointed out, but did not, that the principle of Kapoor case directly negatived the contention when that case held that though the authority of law was not necessary for government to carry on trade, such authority was necessary when it became necessary to encroach upon private rights in order to carry on trade. The Supreme Court distinguished Kapoor case on the ground that it involved no action prejudicial to the rights of others. Even so, Bharat Singh case is really disposed of by the court's observation that every act done by the government or by its officers must, if it is to operate to the prejudice of any person, be supported by some legislative authority, for that is the strict legal meaning of the rule of law. For reasons which I have already given, it was wholly unnecessary to refer to the first meaning which Dicey gave to the rule of law, or to Dicey's contrast between the English and the continental systems. Doctrine of separation of powers. 45. Doctrine of separation of powers. Though the doctrine is traceable to Aristotle 1, but the writings of Locke 2 and Montesquieu 3 gave it a base on which modern attempt to distinguish between legislative, executive and judicial power is grounded. Locke distinguished between what he called 1. Discontinuous legislative power, 2. Continuous executive power, and 3. Federative power. He included within discontinuous legislative power the general rule-making power called into action from time to time and not continuously. Continuous executive power included all those power which we now call executive and judicial. By federative power, he meant the power of conducting foreign affairs. Montesquieu's division of power including a general legislative power and two kinds of executive powers. An executive power in the nature of Locke's federative power, and a civil law executive power including executive and judicial power. Locke and Montesquieu derived the contents of this doctrine from the developments in the British constitutional history of the early 18th century. In England, after a long war between Parliament and the King, they saw the triumph of Parliament in 1688, which gave Parliament legislative supremacy culminating in the passage of the Bill of Rights. This led ultimately to a recognition by the King of legislative and tax power of Parliament and the judicial power of the courts. At that time, the king exercised executive powers, Parliament exercised legislative power and the courts exercised judicial power, though later on England did not stick to the structured classification of functions and changed to the parliamentary form of government. Writing in 1748, Montesquieu said, "When the legislative and executive powers are united in the same person, or in the same body of magistrates, there can be no liberty. Because apprehensions may arise, lest the same monarch or senate should enact tyrannical laws, they execute them in a tyrannical manner. Again, there is no liberty if the judiciary power be not separated from the legislative and executive. Were it joined to the executive power, the judge might behave with violence and oppression. There would be an end of everything, were the same man, or the same body, whether of the nobles or of the people, to exercise those three powers, that of 1. Aristotle, Politics, Vol. IV, 14. 2. The Second Treatise of Civil Government, Chaps. 12 and 13. 3. L'Esprit des Lois, 1748, Chap. 12. Doctrine of Separation of Powers. 46. Exacting laws, that of executing the public resolutions, and of trying the causes of individuals. 4. The doctrine of separation of powers is an animation of the rule of law, and its roots also lie in the concept of natural law because both aim at progressive diminution of the exercise of arbitrary power necessary for protecting the life, liberty and dignity of the individual. It is an organic, flexible doctrine which can be molded to suit the requirements of governance, but its inherent fundamentals and rationality must not be compromised, i.e., accumulation of power is a definition of tyranny. Brandeis J. scientifically explained the purpose of this doctrine when he said that the purpose of the separation of powers doctrine is not to promote efficiency in the administration but to preclude the exercise of arbitrary power. He further emphasizes that its purpose is not to avoid friction amongst various organs of the state by keeping them separate but to protect people from autocracy by means of inevitable friction due of distribution of powers. Is to divide governance against itself by creating distinct centers of power so that they could prevent each other from threatening tyranny. The practical import is that no significant deprivation of life, liberty and dignity of any person can take place unless all the organs of the government combine together. If a person is to be put in jail, then a legislature has to pass a law making his action illegal, executive has to execute the law and judiciary must find him guilty. However, if a person is to be set free then any branch can do it. In Westminster type of democracy where legislature and executive are not separate, judiciary must be separated from the rest. Executive always demands power, at times by threatening insecurity among the people, and legislature would always oblige because it is controlled by the executive. In such situation, judiciary, if separate, would apply brakes and save people from tyranny. It is for this that judiciary has now been separated from Parliament in the UK. The doctrine of separation of powers is based on 4 different principles. 1. Exclusivity principle, which suggests structural division in all the 3 organs of state, as it is in the US. 2. Functional principle, which prohibits amalgamation and usurpation but no interaction of all the organs of state. 3. Check and balance principle, meaning, thereby, that each organ of state may check the other to keep it within constitutional bounds. 4. Mutuality principle, which aims at creating concord not discord, cooperation not confrontation, engagement not estrangement amongst different organs of state to create a society of constitutional image, which is a free, equalitarian, inclusive and rule of law society. 4. Nugent tr. The spirit of the laws, 151-52 quoted in C.K. Thakkar, Administrative Law Eastern Book Company 1992-31. Doctrine of separation of powers. 47. This doctrine can be further used in 2 senses. 1. Negative sense, in which this doctrine puts limits on the exercise of power by each organ of state. And 2. Positive sense, in which it not only demarcates limits but also defines the minimum contents of power within those limits which a court can enforce to achieve constitutional values. 5. Though the doctrine of separation of powers in its classical structural form is not followed in any country, not even in the US, yet logic behind it is still valid, logic of polarity, because threat to liberty arises not from blended powers but unchecked powers. Interaction of power facilitates liberty and freedom. The theory of separation of power signifies 3 formulations of structural classification of governmental powers. 1. The same person should not form part of more than one of the 3 organs of the government. For example, ministers should not sit in parliament. 2. One organ of the government should not interfere with any other organ of the government. 3. One organ of the government should not exercise the functions assigned to any other organ. It may be pointed out that in none of these senses does a separation of power exist in England. The king, though an executive head, is also an integral part of the legislature, and all his ministers are also members of one or the other house of parliament. Therefore, in England the concept of parliamentary executive is a clear negation of the first formulate 3 organs of the government. As regards the second formulation, it is clear that the House of Commons ultimately controls the executive. The judiciary is independent, but the judges of the superior courts can be removed on an address from both houses of parliament. As to the exercise by the one organ of the functions of the other organs, no separation exists in England. Though with the establishment of the UK Supreme Court, judiciary has now been separated from Parliament, yet legislative and adjudicatory powers are being increasingly delegated to the executive. This also distracts from any effective separation of powers. The doctrine of the separation of powers was gospel to the settlers who were obsessed with the violation of their life, liberty and dignity by the monarchs in England, who combined all the powers. Consequently, drafters of the US Constitution made this doctrine the basic brick of the Constitution. Madison said, accumulation of power. Legislative, executive and judicial, in the same hand, whether one, a few or many, whether hereditary, self-appointed or elected, may be justly pronounced as the definition of tyranny. Jefferson also emphasized, concentration of legislative, executive and judicial powers in the same hand is precisely the definition of despotic government. It would be no alleviation that these powers will be exercised by plurality of hands and not by a single person. 173 despots would surely be as oppressive as one. Thus, this doctrine forms the foundation on which the whole structure of the US Constitution is based. Article 1, Section I vests all legislative powers in the Congress. Article 5C, State of UP vs. G.T.S. Bishop, 2076 SC 586. Doctrine of Separation of Powers. 48. 2. Section I vests all executive powers in the President of the U.S. Article 3, Section I vests all judicial power in the Supreme Court. It is on the basis of this theory of separation of powers that the U.S. Supreme Court has not been given power to decide political questions, so that the court may not interfere with the exercise of power of the executive branch of the government. The U.S. Constitution has also not given overriding power of judicial review to the U.S. Supreme Court. It is a queer fact of American constitutional history that the power of judicial review has been usurped by the court. However, American constitutional developments have shown that in the face of the complexity of modern government, strictly structural classification of the powers of the government is not possible. The President of the U.S. interferes with the exercise of powers by the Congress through the exercise of his veto power. He also exercises the law-making power in exercise of his treaty-making power. This President also interferes with the functioning of the Supreme Court through the exercise of his power to appoint judges. In fact, President Roosevelt did interfere with the functions of the court when he threatened to pack the court in order to get the court's support for his New Deal legislation. The same manner, Congress interferes with the powers of the President through vote on budget, approval of appointments by the Senate and the rectification of treaty. Congress also interferes with the exercise of powers by the courts by passing procedural laws, creating special courts, and approving the appointment of judges. In its turn, the judiciary interferes with the powers of the Congress and the President through the exercise of its power of judicial review. It is correct to say that the U.S. Supreme Court has made more amendments to the U.S. Constitution than the Congress itself. Though no separation of powers in the strict sense of the term exists in England and the US, yet the curious fact is that this doctrine has attracted the markers of most modern constitutions, especially during the 19th century. Thus in France, the doctrine has produced a situation in which the ordinary courts are precluded from reviewing the validity not only of legislative enactments but even of the actions of the administration. The void has been filled by the establishment of special administrative courts. In India, the doctrine of separation of powers has not been accorded a constitutional status. Apart from the directive principle laid down in Article So, which enjoins separation of judiciary from the executive, the constitutional scheme does not embody any formalistic and dogmatic division of powers. 6. The Supreme Court in Ram Javier Kapoor v. State of Punjab 7 held. Indian Constitution has not indeed recognized the doctrine of separation of powers in its absolute rigidity, but the functions of the different parts or branches of the government have been sufficiently differentiated, and consequently it can very well be said that our Constitution does not contemplate assumption, by one organ or part of the state, of functions that essentially belong to another. 6. Upendra Baxi, Development in Indian Administrative Law, in A.G. Noorani ed. Public Law in India 1982-1367 air 1955 SC 549. 49. The Interpretation of Statutes. Glanville Williams. The context rule in ordinary life: if someone says something that you do not understand, you ask him to explain himself more fully. This is impossible with the interpretation of statutes, because when Parliament has passed an act, the words of the act are authoritative as words. It is only these words that have passed through the legal machinery of lawmaking, and individual members of Parliament cannot be put into the witness box to supplement or interpret what has been formally enacted. Hence the words of an act carry a sort of disembodied or dehumanized meaning. Not necessarily the meaning intended by any actual person in particular, but the meaning that is conventionally attached to such words. The point must not be pressed too far, since the statute obviously has a broad purpose, or, to speak more precisely, those who collaborated in framing and passing the statute had a broad purpose which is expressed in the words. The most important rules for the interpretation, otherwise called construction, of statutes are those suggested by common sense. The judge may look up the meaning of a word in a dictionary or technical work. But this ordinary meaning may be controlled by the particular context. As everyone knows who has translated from a foreign language, it is no excuse for a bad translation that the meaning chosen was found in the dictionary. For the document may be its own dictionary, showing an intention to use words in some special shade of meaning. This rule, requiring regard to be had to the context, is sometimes expressed in the Latin maxium nocitur associes, which Henry Fielding translated. A word may be known by the company it keeps. One may look not only at the rest of the section in which the word appears but at the statute as a whole, and even at earlier legislation dealing with same subject matter, for it is assumed that when Parliament passed an act, it probably had the earlier legislation in mind, and probably intended to use words with the same meaning as before. 8. Somewhat anomalously, reference may even be made to later statutes, to see the meaning that Parliament puts on the same words in a similar meaning that Parliament puts on the same words in a similar context. However, words need not always have a consistent meaning attributed to them. The context may show that the same word bears two different senses even when it is repeated in the same section. 9. Formally, the rule permitting recourse to earlier statutes was taken to allow the court to compare the wording of a Consolidation Act with the acts that it superseded, and to conclude that variation of wording indicated a change of meaning. But this tended to defeat the object of consolidation, which was to supersede a jumble of acts of various dates by a single statute. Consolidation would be little help if one still had to look at the old repealed acts in order to. 8. Maxwell, Interpretation of Statutes, 12th ed. 64 et Suc. 9 R. V. Allen 18721 CCR at 374. West Midlands Joint Electricity Authority v. Pitt 1932 2 KB at 46. 50. Interpret the new one. Consequently, the rule now laid down by the House of Lords is that wherein construing a Consolidation Act, the actual words are clear and unambiguous, it is not permissible to have recourse to the corresponding provisions in the earlier statute repealed by the Consolidation Act and to treat any difference in their wording as capable of casting doubt upon what is clear and unambiguous language in the Consolidation Act itself. 10. In reading a statute, always look for a definition section assigning special meanings to some of the words in the statute. Parliamentary counsel have the inconsiderate habit of not telling you, for example, in a footnote or marginal note, that a particular word in the section is defined somewhere else in the statute. You have to ferret out the information for yourself. Interpretation in the light of policy, fringe meaning. When interpreting statutes, the court often announce that they are trying to discover the intention of the legislature. In actual fact, if a court finds it hard to know whether a particular situation comes within the words of a statute or not, the probability is the situation was not foreseen by the legislature, so that the Lords and members of Parliament would be just as puzzled by it as the judges are. Here, the intention of the legislature is a fiction. Because of this difficulty, some deny that the courts are really concerned with the intention of Parliament. In the construction of written documents including statutes, what the court is concerned to ascertain is, not that the promulgators of the instruments meant to say, but the meaning of what they have said. 11 others, however, think it proper to speak of the intention of Parliament, in the sense of, the meaning which Parliament must have intended the words to convey. 12 In case of doubt, the court has to guess what meaning Parliament would have picked on if it had thought of the point. The intention is not actual but hypothetical. 13 There is, of course, a limit to what a court can do by way of filling out a statute, but to some extent this is possible. All illustration is the familiar legal problem of fringe meaning. The words we use, though they have a central core of meaning that is relatively fixed, have a fringe of uncertainty when applied to the infinitely variable facts of experience. For example, the general notion of a building is clear, but a judge may not find it easy to decide whether a temporary wooden hut, or a telephone kiosk, or a wall, or a tent, is a building. In problems like this, the process of interpretation is indistinguishable from legislation. The judge is, whether he likes it or not, a legislator. For, if he decides that the wooden hut is a building, he is in effect adding an 10 per Lord Diplock in Curran 19761 WLR at 90H91A, 1976 1 All ER at 165B. Reaffirmed by a majority of the Lords in Farrell v. Alexander, 1977 AC 59. See the reservations by Lord Simon at p. 84. 11 per Lord Simon in Farrell v. Alexander, 1977 AC at 81G. 12 per Lord Edmund Davies, Ibid. At 95B. 13 Even this formulation of the judge's task has an element of unreality, as Professor Dworkin has pointed out. 64 Proc. Brit. AC. 259. Even if the legislature had thought of the point, it might have preferred to leave it unresolved, for example, because to resolve it would arouse the opposition of some group or other and imperil the whole measure, or because it would encumber the act with too much detail. 51. Interpretation clause to the statute which gives, building, an extended application. Whereas if he decides that the hut is not a building, he adds a clause to the statute which gives it a narrower meaning. The words of the statute, as they stand, do not give an answer to the question before the judge. And the question is therefore legislative rather than interpretative. This simple truth is rarely perceived or admitted. Almost always the judge pretends to get his solution out of the words of the act, though he may confess in so doing to be guided by its general policy. The rational approach would be to guide it by its general policy. The rational approach would be to say candidly that the question, being legislative, must be settled with the help of the policy implicit in the act, or by reference to convenience or social requirements or generally accepted principles of fairness. This kind of interpretation may be legally and socially sound, although it reaches results that would surprise the lexicographer. Thus, it has actually been held that murder can be an accident. 14. The word accident was being interpreted in the context of the Workmen's Compensation Act, and the result of the decision was that the widow of the deceased workman was entitled to compensation from the employer. 15. Because the murder in question arose out of and in the course of the employment. The mischief rule. The task of interpreting statutes gives judges the chance of expressing their own opinions as to social policy. And, inevitably, their opinions do not always command universal assent. However, the judges are on fairly safe ground if they apply the mischief rule, otherwise known as the rule in Hayden's case. 16. This bids them to look at the legal position before the act, and the mischief that the statute was intended to remedy. The act is then to be constructed in such a way as to suppress the mischief and advance the remedy. The practical utility of the rule depends to some extent upon the means that the courts are entitled to employ in order to ascertain what mischief the act was intended to remedy. A true historical investigation would take account of press agitation, party conferences, government pronouncements, and debates in parliament. But all these are ignored as the result of a rule exclusively evidence of the political history of a statute. The rule is justified by the burden that would be placed upon legal advisers and the uncertainty that would be introduced into the law if such historical materials had to be consulted. 17. In practice, therefore, the judge. 14. Nisbet v. Train and Burnt 1910 2 KB. 689. 15. Now turned into industrial injuries benefit as part of the National Insurance Scheme Social Security Acts 1975 to 1977. 16. 15842 Company. Representative. At 7b, 76 ER at 638 17. Although the reason is convincing, the rule sometimes has unhappy consequences. On one occasion, when a section was included in an act for the avowed purpose of getting rid of a certain decision, a divisional court, not realizing this, followed the decision, whittling down the section by applying rules of interpretation, and saying that Parliament could not have intended to change the law. See Cretny in 119 NLJ 301. Exceptionally, where a statute is passed to give effect to an international treaty convention, the courts will apply the continental rule that the discussions leading to the treaty may be looked at. Fothergill v. Monarch Airlines Limited. 1981 AC 251. But Lord Scarman said that such Trevo 52 generally divines the object of a statute merely from perusal of its language, in the light of knowledge of the previous law and general knowledge of social conditions. 18. Many statutes are the result of recommendations made by the Royal Commissions and departmental committees. Can the reports of these commission and committees be looked at as an aid to construction? The rule is now settled is that they are inadmissible in order to show what the committee through its proposals meant, but admissible under the rule in Haydown's case to the extent that they show the mischief against which the act was directed. It may be expected that the practice of referring to these reports will extend itself in the future, because they often supply the best commentary upon the wording of an act. 19. The literal rule. Granted that words have a certain elasticity of meaning, the general rule remains that the judges regard themselves as bound by the words of a statute when these words clearly govern the situation before the court. The words must be applied with nothing added and nothing taken away. More precisely, the general principle is that the court can neither extend the statute to a case not within its terms, though perhaps within its purpose the casus omissus, nor curtail it by leaving out a case that the statute literally includes, though it should not have. There is no accepted name for the latter, but it may be called the casus male inclusus. Lord Diplock expressed the point as follows: at a time when more and more cases involve the application of legislation which gives effect to policies that are the subject of bitter public and parliamentary controversy, it cannot be too strongly emphasized that the British Constitution, though largely unwritten, is firmly based upon the separation of powers. Parliament makes the laws, the judiciary interpret them. When Parliament legislates to remedy what the majority of its members at the time perceive to be a defect or a lacuna in the existing law, whether it be the written law enacted by existing statutes or the unwritten common law as it has been expounded by the judges in decided cases, the role of the judiciary is confined to ascertaining from the words that Parliament has approved as expressing its intention what that intention was, and to giving effect to it. Where the meaning of the statutory words is plain and unambiguous, it is not for the judges to invent fancied ambiguities as an excuse for failing to give effect to its plain meaning because they themselves consider that the consequences of doing so would be inexpedient, or even unjust or immoral. In controversial matters such as are involved in industrial relations, there is room for differences of opinion as to what is expedient, what is just, and what is morally justifiable. Under our Constitution, it is Parliament's opinion on these matters that is paramount. 20. Preparatoires should be used only where the text is ambiguous or where a literal construction appears to conflict with the purpose of the treaty. 18 CEG Davis v. Johnson 1979 AC at 338 F. 19 See the close vote on this subject in Black Clawson International Limited. V. Papier Worker Waldhofer Schaffenberg AG 1975 AC 591, discussed by Sir Rupert Cross, Statutory Interpretation 1976 136 et Suc. 20 Depot Steels Limited. V. Sirs 1981 WLR at 157, 1 All ER 529. For earlier pronouncements to the same effect see Magor and St. Mellons v. Newport Coppin 1952 AC 189. Stock v. Frank Jones Tipton Limited. 1978 1 WLR 231, 1 All ER 948. 53. The rule has often been criticized by writers. What is a real ambiguity, and what is a fancied ambiguity? Consider the following case decided by the House of Lords on the construction of the Factories Act. 21. This act requires dangerous parts of machines to be constantly fenced while they are in motion. A workman adjusting a machine removed the fence and turned the machine by hand in order to do the job. Unfortunately, he crushed his finger. Whether the employers were in breach of the statute depended on whether the machine was in motion. In the primary or literal sense of the words it was, but since the machine was not working under power and was only in temporary motion for necessary adjustment, the House of Lords chose to give the words the secondary meaning of mechanical propulsion. 22. Since the machine was not being mechanically propelled, it was not in motion. The literal rule is a rule against using intelligence in understanding language. Anyone who is ordinary life interpreted words literally, being indifferent to what the speaker or writer meant, would be regarded as a pedant, a mischief maker, or an idiot. One practical reason for the literal rule is that judges are now deeply afraid of being accused of making political judgments at variance with the purpose of Parliament when it passed Act. This fear is sometimes understandable, but not all statutes divide Parliament on party lines. Other reasons advanced for the literal rule may be briefly answered. 23. Many statutes are passed by political bargaining and snap judgments of expediency. The courts can rarely be sure that Parliament would have altered the wording if it had foreseen the situation. This may be true, but is it any reason why the courts should not do justice as best they can, leaving it to Parliament to intervene again if the decision does not meet with Parliament to intervene again if the decision does not meet with Parliament to intervene again if the decision does not meet with Parliament's approval? If courts habitually rewrote statutes in order to effect supposed improvements, this might cause statutes to become more complex in order to exclude judicial rewriting in a way that was politically unacceptable. This supposes that the court misjudges what Parliament would wish it to do, whereas in fact the decision may win general approval. A court that tries to decide as Parliament would have wished is more likely to be right than a court that follows the words believing it was not what Parliament intended. People are entitled to follow statutes as they are. They should not have to speculate as to Parliament's intention. This is a strong reason against the extensive construction of prohibitory legislation, but not in other cases. If the courts undertook to rewrite statutes, this would tend to foment litigation, because it would encourage people who objected to the legislation to try their luck with the courts. To suggest that the courts will ever completely rewrite a statute is a great exaggeration. And even judges who accept the literal rule in words will depart from it when the circumstances press them hard enough. 21. Currently the Factories Act 1961. 22. Richard Thomas and Baldwin's Limited. Cummings 1955 AC 321. For a fuller discussion see Cross, Op. Cit. 29 to 31, 74 to 84. 23. Some of these reasons are given by Lord Simon in Stock v. Frank Jones Tipton Limited. 1978 1 WLR at 236 to 237, 1 all ER at 953 to 954, but the above paragraph does not represent direct quotation. 54. Lord Diplock says that there may be differences of opinion as to what is expedient, just and moral, and that Parliament's opinion on these questions is paramount. This is obviously true, once Parliament's opinion is established. It is also true that Parliament's opinion is ascertained primarily from the words it has used. Nevertheless, the facts of the case may be such as to raise serious doubts whether Parliament intended its words to apply. The decision by a court that a particular situation was not intended to come within the ambit of a statute, though within its words in what may be their most obvious meaning, does not deny the supremacy of Parliament, for if Parliament disagrees with the decision it can pass another act dealing specifically with the type of case. However, the hard truth is that Parliament generally pays little attention to the working of the law. It is not merely that Parliament fails to keep old law under continuous revision. It loses interest in its new creations as soon as they are on the statute book. Interpretations to avoid absurdity, the golden rule. As the Factories Act case illustrates, the courts sometimes allow themselves to construe a statute in such a way as to produce a reasonable result, even though this involves departing from the prima facie meaning of the words. The rule that a statute may be constructed to avoid absurdity is conveniently called the golden rule. 24. It is by no means unlimited, and seems to apply only in 3 types of case. In its first application, the golden rule allows the court to prefer a sensible meaning to an absurd meaning, where both are linguistically possible. It does not matter that the absurd meaning is the more natural and obvious meaning of the words. Lord Reed, where a statutory provision on one interpretation brings about a startling and inequitable result, this may lead the court to seek another possible interpretation which will do better justice. 25. On another occasion, Lord Reed put the point more strongly. It is only where the words are absolutely incapable of a construction which will accord with the apparent intention of the provision and will avoid a wholly unreasonable result that the words of the enactment must prevail. 26. This application of the golden rule does not contradict the literal rule, provided that the absurdity of the particular proposed application of the statute is conceded to be a reason for finding an ambiguity in it. If one accepts the golden rule, this involves rejecting Lord Diplock's opinion that the inexpediency, injustice or immorality or the proposed application of the statute cannot in itself be a reason for finding an ambiguity in the statute. According to the golden rule, it can be a powerful motivating force leading the court to detect such an ambiguity. 24. Mattison v. Hart 1854-14 CB at 385, 139 ER at 159. The general statement of the golden rule is that 1. The literal primary meaning must be adopted unless 2. This results in absurdity. It is convenient to take the golden rule as meaning 2 alone, since this is what it adds to the literal rule. But some judges use the phrase to refer to meaning 1 alone. 25. Coutts and Company. V. IRC 1953 AC at 281. 26. Luke v. IRC 1963 AC at 577. 55. It is frequently said that the question of absurdity cannot influence a decision in any type of case except the one just stated. Nevertheless, the courts sometimes act on a second principle, stated by Cross as follows. The judge may read in words which he considers to be necessarily implied by words which are already in the statute, and he has a limited power to add to, alter or ignore statutory words in order to prevent a provision from being unintelligible or absurd or totally unreasonable, unworkable or totally irreconcilable with the rest of the statute. 27. Acting on this principle, judges have occasionally corrected a statute that foolishly and, when it meant, or that foolishing said, or, when it meant, and. However, the argument must be very strong to induce the court to meddle with a statute in a way that they themselves acknowledge creates outrageous injustice. 27 Cross Op. Sit. 84 to 98. Custom is a source of law in India. 56. Custom